You can read the first one and the second.
Order number one, administration of oath. Order number 2, communication from the chair. Order number 3, messages. Order number 4, petitions.
Now, honourable members, the member from Vita, you can take your seat. Now, honourable members, honourable members, as you may have noticed, I do appreciate that every day we get new members attending. Like I'm sure the ones who are today here will not be there on Tuesday because of the various things that are happening. With a few exceptions of the Deputy Speaker, Majority Whip, and the Honourable Wandai, Honourable Marie, Honourable Wanyonyi, Honourable Wamunyinyi, Honourable Abdul Swamad. Now, I've noticed that if we go through the normal motions, because now the next order is order number 5, papers, there are some members who have no capacity to sit here beyond 5 minutes. So, and we have been unable to transact certain businesses because they disappear too fast. Now, I'm rearranging the order paper so that we move to order number 9, 10, 11, 12, 13 and 14 in that order before we go back to order number 5 for papers to be laid, because I'm sure by the time we are through with that, we are likely to have dissipated a bit. But for the time being, honourable members, there's even a member who was coming now, she's walking away. She has just finished and walked away. No, there's no need of naming anybody now, I think. So I'll just request that those of you who are present, please, let us be able to dispose of these businesses, because it's just by way of putting the question and the decision being taken. So please, I know there are some of you who already now have sat for too long, but please, just from here for another 10 minutes, we'll be through. Clerk.
Order number 9, motion. Report of the Committee of Supply on budget estimates for the financial year 2022-2023. Question to be put.
Now that member who is walking out, is this the Honourable Kilonzo? Oh, good. You see, the Honourable Kilonzo has gotten thirsty. Those ones making your way, please come in. Honourable members, debate on this motion was concluded, and what remained is for the question to be put, which we couldn't put on Tuesday because we did have quorum. And like I said, honourable members, quorum is important when you are making a decision. So I put the question that this House do agree with the report of the Committee of Supply in its consideration of the budget estimates for the financial year 2022/2023, and pursuant to the provisions of Article 221 of the Constitution, Section 39 of the Public Finance Management Act of 2012, and standing under number 240A, approves the issuance of a sum of Kenya shillings 2,103,838,900,000 811,446 from the Consolidated Fund to meet the expenditure for the national government during the year ending 30th June 2023 in respect to the votes as approved in the schedule to the order paper. Will as many as of that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it. Next.
Order number 10, motion. Report of the Committee of the Whole House on the National Government Constituency Development Fund Amendment Bill, National Assembly Bill number 4 of 2021. Question to be put.
The chair of Budget and Appropriations Committee was not even in himself when we were dealing with his business. Well, honourable members, again, this is just to put the question, which I hereby do. Now, this House do agree with the report of the Committee of the Whole House on its consideration of the National Government Constituencies Development Fund Amendment Bill, National Assembly Bill number 4 of 2021. Will as many as that opinion say aye? Aye. As many as contrary opinion say nay? The ayes have it. Is it the mover? Mover vote. Move for that reading.
Thank you, Honorable Speaker. I beg to move that the National Government Constituency Development Fund Amendment Bill, National Assembly Bill number 4 of 2021, be now read a third time. And I also want to ask the Honorable Ferdinand Wanyonyi to second.
Honorable Wanyonyi, member for Kwanza.
Speaker, I second.
Very honourable members, I propose the question, which is that the National Government Constituencies Development Fund Amendment Bill, National Assembly Bill number 4 of 2021, be now read a third time. Honourable members, there being nobody making any comments, and having confirmed that the House still has quorum, I now put the question, which is that the National Government Constituencies Development Fund Amendment Bill, National Assembly Bill number 4 of 2021, be now read a third time. Will as many as of that opinion say aye? Aye. Will as many as of contrary opinion say nay? The ayes have it.
A bill for an act of parliament to amend the National Government Constituencies Development Fund Act 2015.
Next order.
Order number 11, the Supreme Court Amendment Bill, National Assembly Bill number 15 of 2022, question, second reading. Question to be put.
Honourable members, debate on this bill was concluded on Tuesday this week. What it means is the question to be put, which I hereby do. That the Supreme Court's Amendment Bill, National Assembly Bill number 15 of 2022, be now read a second time. Will as many as that opinion say aye? Aye. As many as the contrary opinion say nay? The ayes have it.
A bill for an act of parliament to amend the Supreme Court Act and for connected purposes.
Next.
Order number 12, the Prompt Payment Bill, Senate Bill number 16 of 2021, second reading. Question to be put.
This member who is, why can't you take a seat? The member for Kilifi North. The honourable member is not coming in. It's like somebody who is a friend of the ocean. Again, honourable members, I put the question, which is that the Prompt Payment Bill, Senate Bill number 16 of 2021, be now read a second time. Will as many as that opinion say aye? Aye. As many as contrary opinion say nay? The ayes have it.
A bill for an act of parliament to provide for prompt payment for the supply of goods, works, or services and for connected purposes.
Next.
Order number 13, motion, approval of amendments to the standing orders. Question to be put.
Now, those two lady members, or you are through. Surely, oh no, member, just be patient. We are going to be through. We will release you, but we will still continue to make law for the country. I hope you are part of the team that is making the law. Honourable members, I put the question, debate having been concluded, which is that this House adopts the fifth report of the Procedure and House Rules Committee on amendments to the standing orders laid on the table of the House on Thursday, May 26, 2022, and pursuant to provision standing order 264, under 264 and 265, approves the proposed amendments to the standing orders as contained in the first schedule to the report, and further resolves that 1. Pursuant to the provisions of Standing Order 265, the amendments made to the standing orders shall commence upon the expiry of the term of the 12th Parliament, and 2. Despite paragraph 1 above, the proposed new standing orders, Standing Order 259F, subsection 5, which is about members' biodata and roll, shall take effect immediately. Will as many as that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it. I only hope members know that I'm sure many of you may not know this procedure, that this is the only time normally that when we move into committee of the whole House, the Speaker will leave the chair and go to the chairman's chair to deal with the amendment to the standing orders. Let's move to the next order.
Order number 14, motion, report on the examination of the financial statements for the national government for the financial year 2018-2019. Question to be put.
Members, this is a report by the Public Accounts Committee, and the Honourable and I indicated that he threatened to table yet another report before the House goes to recess sine die, and we'll still continue to congratulate him and his committee for the work well done. So debate on this report was concluded on Tuesday this week, and what remained is for the question to be put, which I hereby do. That I put the question that this House adopts a report of the Public Accounts Committee on the examination of the report of the Auditor General on the financial statements for the national government for the financial year 2018-2019, laid on the table of the House on May 17, 2022. Will as many as of that opinion say aye? Aye. Will as many as the contrary opinion say nay? The ayes have it. Now, so this paves the way for the Honourable and I to table the report for the financial year 2019-2020. And that is really commendable. Honourable and I. So, you know, we actually stopped so that we could dispose of these questions, because so we will go now back to order number 5.
Order number 5, papers.
Majority Whip.
Thank you, Honourable Speaker. Honourable Speaker, I beg to lay the following papers on the table of the House today, Thursday, June 2nd, 2022. 1. Bilateral air service agreements between Kenya and Czech Republic, Cyprus, Chile, Belize, Suriname, Tanzania, Austria, and Barbados, and the explanatory memorandum. 2. Protocol relating to Articles 50A and 56 of the Convention on International Civil Aviation, 1994, and explanatory memorandum. 3. Report of the Auditor General for the national government, ministries, departments, and agencies for the year 2020-2021. And lastly, 4. Report of the Auditor General and financial statements in respect of Tinderet constituency for the year ended 30th June 2019 and the certificate therein. Thank you, Honorable Speaker.
The Chairman, Departmental Committee on Agriculture. Honorable Tiren.
Yes, Honorable Speaker, thank you. Thank you, Honorable Speaker, for the opportunity. Honorable Speaker, sir, I beg to lay the following papers on the table of the House today, Thursday, June 2nd, 2022. Reports of the Departmental Committee on Agriculture and Livestock on its consideration of the following. 1. The Mung Beans Bill, Senate Bill number 9 of 2020. 2. Public petition regarding Mirau farming and marketing. And 3. The public petition regarding restoration of revival of Kenya Cashew Nuts Factory. Thank you very much, Honorable Speaker.
The Chair, Public Investments Committee. But before the Chair, Public Investments Committee tables his report, let me recognize the presence in the public gallery of pupils from Mweki Primary School in Roiro constituency, Kiambu County. I tell them that they are welcome to observe the proceedings of the National Assembly this afternoon. Chair, Public Investments Committee.
Thank you very much, Mr. Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Thursday, June 2nd, 2022, the report of the Public Investment Committee on its consideration of the Special Audit Report on the Lake Turkana Wind Project.
Chairperson or Chairman, Transport, Public Works and Housing, Honorable Kosing.
I thank you, Honorable Speaker. Honorable Speaker, I beg to lay the following paper on the table of the House today, Thursday, June 2022. The report of the Departmental Committee on Transport, Public Works and Housing on its consideration of the Kenya Roads Board Amendment Bill, National Assembly Bill number 13 of 2022. I thank you, Honorable Speaker.
Very well. Next is the Chairman, Committee on Delegated Legislation, the Honorable Kamket.
Mr. Speaker, sir, I beg to lay the following paper on the table of the House today, Thursday, June 2nd, 2022. Report of the Committee on Delegated Legislation on its consideration of, number 1, the draft elections registration of voters amendment regulations 2022. 2, the draft elections general amendment regulations 2022. 3, the draft elections voter education amendment regulations 2022. 4, the draft elections party nominations and party lists amendment regulations 2022. And 5, the draft elections technology amendment regulations 2022. I thank you.
Very well. Next order.
Order number 6, notices of motion.
Honorable Abdul Samad.
Honorable Speaker, I beg to give notice of the following motion that this House adopts the special audit report on the Lake Turkana wind project laid on the table of the House on Thursday, June 2nd, 2022.
Honorable Kamket.
Yeah, Mr. Speaker, sir, I beg to give notice of the following motion. That this House adopts the report of the Committee on Delegated Legislation on its consideration of the draft elections, registration of voters amendment regulations 2022, the draft elections general amendment regulations 2022, the draft elections voter education amendment regulations 2022, the draft elections party nominations and party lists amendment 2022 regulations, and the draft elections technology amendment regulations 2022 laid on the table of the House on Thursday, June 2nd, 2022, and pursuant to the provisions of Section 109(3) of the Elections Act 2011, does not approve the draft election regulations. I thank you.
You know, this one, equal members, they already done. Very well. Next order. No question.
Notice.
Oh, yeah. Sorry. Majority Whip.
Thank you, Honorable Speaker. Honorable Speaker, I beg to give notice of the following motion that, pursuant to the provisions of Section 52 of the Public Finance Management Act 2012, this House approves the Public Finance Management in brackets National Government Amendment Regulations 2022, published as legal notice number 89 of 26th May 2022, thus approving the amendment made to the Public Finance Management in brackets National Government Regulations 2015 Principal Regulations in Regulation 26(1) by deleting paragraph C and substituting therefore the following paragraph C. Pursuant to the provision of Section 50 in brackets 2 of the Act, the public debt shall not exceed 10 trillion shillings. Thank you, Honorable Speaker.
Very well. Next order.
Order number 7, questions and statements.
Member for Bomet Central.
Thank you, Mr. Speaker. I arise to ask the following questions, the Cabinet Secretary for Education. 1, could the Cabinet Secretary explain the inordinate delays by the Kenya National Examination Council in making payments to invigilators, supervisors, examiners, and other personnel who rendered services during the administration and marking of 2021 Kenya Certificate of Secondary Education, KCSE examinations, and Kenya Certificate of Primary Education, KCPE. 2, when will the teachers be paid who rendered their services? Thank you.
The question will be responded to before the Departmental Committee on Education. The next segment is on statements. The only statement I expect today is from the leader of from the Majority Whip.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provisions of Standing Order 44-2A, I rise to give the following statement on behalf of the House Business Committee regarding the business prioritized for consideration. Honorable Speaker, as members are aware, the House has allocated a significant portion of this time to considering the budget estimates for the financial year 2022-23 and other related legislations. I want to thank the leadership of the House and all members for the cooperation we have had so far. We still have a few important stages to go through in this regard, including passage of the Appropriation Bill and the Finance Bill 2022. which will be considered today in committee of the whole House. I therefore urge members to be patient and support the House leadership in finalizing this critical part of the budget process, especially where the House may have to sit late to conclude the business. Honorable Speaker, on Tuesday next week, the following business has been scheduled for consideration. 1. First reading of the Appropriation Bill 2022, subject to its publication. 2. Second reading of the following bills. 1. The Appropriation Bill 2022. 2. The Beans Bill, Senate Bill number 9 of 2020. And 3. The County Boundaries Bill, Senate Bill number 20 of 2021. 3. Committee of the whole House on the following bills. 1. The Appropriation Bill 2022. 2. The Supreme Court Amendment Bill 2022. And 3. The Universities Amendment Bill 2021. Honorable Speaker, also scheduled for consideration are motions on the following matters. 1. Report of the Budget and Appropriation Committee on the consideration of the second supplementary estimates for the financial year 2021-2022. 2. Report of the Public Investments Committee on the examination of the financial statements for state corporations. And 3. Report of the Committee on Member Services and Facilities on the study visit to the Legislative Assembly of Alberta, Canada. Honorable Speaker, I am reliably informed that at the moment there are no questions scheduled for response by Cabinet Secretaries. Honorable Speaker, the House Business Committee shall reconvene on Tuesday, 7th June 2022 to schedule the business for the rest of the week. Honorable Speaker, I now wish to lay this statement on the table of the House. Thank you, Honorable Speaker.
Member for Igembe South.
Asante sana Bwana Spika. Bwana Spika, nataka kukushukuru sana sababu wiki mbili zilizopita nilisimama katika bunge hili kuuliza ombi kutoka kwako ya kwamba kuna maombi nilikuwa nimeleta hapa mwaka wa 2020 na wakati ambapo nilileta hili ombi alikuwa limeshughulikiwa sababu lilikuwa ombi la mwananchi wa Igembe Kusini, mwananchi ambaye alikuwa amefungiwa soko ya miraa, na hili ombi niliweza kulileta kwa kamati ya kilimo. Na siku ya leo Bwana Spika, nashukuru pia kiongozi wa ile kamati sababu ameweza kuleta yale majibu katika bunge hili. Ni ombi langu sana wizara sababu Bwana Spika, haya maombi yamekaa kwa muda mrefu sana na wananchi wangu wa Igembe Kusini wametaabika sana sababu wakati ambapo miraa ilifungwa hawanja kuwa na soko mahali popote, na kwa hivyo wamekuwa na shinda nyingi. Kwa hivyo nashukuru sana na naomba sababu hili ombi leo limeweza kujibiwa au wananchi waweze kushughulikiwa ili biashara iweze kufunguliwa tena. Pesa ambazo zilikuwa zimetumika sababu kuna pesa serikali ilikuwa imepeana mwaka wa 2016-2017 pia hizo ziweze kutumika kusaidia huyu mkulima sababu kuna maombi ya uchunguzi pia yalikuwa pale ili wizara ya kilimo iweze kuangazia vyema ni vipi ambavyo waliweza kutumia hizi hela kusaidia mwananchi wa kule Meru. Bwana Spika, kwa hivyo nashukuru sana na hiyo ripoti iweze kutimizwa kikamilifu. Nashukuru sana na Bwana Spika, pia tukitoka bunge hili naomba Mungu sana mahali ambapo utakuwa vile ambavyo unatusaidia hapa uzindi kusaidia. Asante sana.
Honorable Shoma, you also have an intervention.
Yes. Asante Mheshimiwa Spika. Naomba pia nichangie hiyo ripoti kwa lugha ya Kiswahili sababu Mheshimiwa John Paul amechangia kwa lugha ya Kiswahili. Na ni dhahiri ya kuwa shida ya wakulima wa miraa, Mheshimiwa Spika, sisi sote tunajua sio shida hasa ambayo kiini chake ni wakulima. Kiini cha matatizo ya wakulima wa miraa ni mambo ya soko la miraa. Na Mheshimiwa Spika, tumetumia soko la miraa kama chombo cha siasa kwa miaka mingi. Na ni jambo la kushangaza ya kuwa waziri anayesimamia kilimo kwa wakati huu, Mheshimiwa yule Munya. Na Munya unajua kwa nyumbani ni huko Meru ambako kuna wakulima wengi wa miraa. Lakini pia unajua jina lake Munya kwa kikwetu ni kung'oa. Na sijui kama aliambiwa na mtu yeyote ya kuwa kazi yake ni kung'oa maisha ya wakulima, sababu ndiye tatizo kuu la wakulima wote. Mambo ambayo yamewekwa fedha za serikali kama hiyo ilikuwa ya miraa na matumizi mabaya kwa wizara hiyo. Mheshimiwa Naibu wa Rais, unakumbuka juzi wakulima waliahidiwa ya kuwa atapewa mbolea ambayo bei yake imesaidiwa kukatwa bei na serikali, na akakimbia Trans Nzoia huko Kitale kufanya wakulima wapange laini siku mzima bila kupata mbolea, na wenye walipewa napewa kila mtu ngunia 10 ama 6, ilhali ni mkulima ambaye anahitaji ngunia 100 ama 200 za mbolea. Kwa hivyo nataka niseme mpaka waziri anayesimamia kilimo aache kufanya siasa na mambo ya wakulima na maisha ya wakulima. Awe na ule moyo wa kujua ya kuwa wakazi wa Meru, wakulima hasa wale wa Igembe na Tigani ambao wanategemea kilimo cha miraa, ni watu ambao jamii zao na familia zao zinategemea kilimo cha miraa. Kwa hivyo anapofanya siasa za miraa, na inashangaza Mheshimiwa Spika, nimemuona huyo waziri kinyume cha katiba akitembea kote nchini kufanya kampeni za kisiasa, akiahidi Wakenya mambo ambayo watafanya na serikali nyingine akiwa waziri wa kilimo. Sasa nashangaa kujiuliza Mheshimiwa Spika, mambo gani waziri ambaye saa hii ako serikalini kama waziri wa kilimo anawaahidi wananchi ya kuwa atayafanya na serikali nyingine akiwa kilimo? Labda atuambie tatizo, kama sio yeye tatizo basi iwe ni wakuu wake. Atuambie kuwa aliyemteua saa hii ako na tatizo ambazo anazuia yeye kutekeleza kama waziri, na atuambie yule anayemfanyia kampeni wakati huu kinyume cha katiba, Mheshimiwa Spika, sababu hakuna waziri na sijui nini nawasha wengine, sababu naongea mambo ya kikatiba. Katiba yetu ndio imetuambia hakuna waziri anayefaa kuwa akifanya siasa.
Shukran Mheshimiwa Spika. Mheshimiwa Spika, naomba kushukuru sana kwa kunipa nafasi hii ili niulize swali haswa kwako kama Spika, kuwa kama mwenzangu mbunge wa Kikuyu ako kikanuni kumtaja kisha kumuongelea Mheshimiwa waziri bila hoja sawa kinyume ya kanuni za hili bunge. Mheshimiwa Spika, yale maombi ambayo Mheshimiwa Ishungu alikuwa nayo yalikuwa mazuri bila kumuongelea Mheshimiwa Munya. Lakini vile ninavyoendelea, kama nauliza Mheshimiwa Spika kama yeye yuko sahihi kuendelea namna hivyo. Asante Mheshimiwa Spika.
Unajua Bwana Spika, na mheshimu sana Mheshimiwa Kiraja wa chama cha Jubilee, lakini sijui kama anaelewa hiyo katiba anayoongelea. Jukumu langu moja kuu kama mbunge wa Kikuyu ni kuhakikisha ya kuwa utekelezaji wa kazi za serikali na mawaziri waliopewa kazi na serikali ama na rais unafanyika kwa mujibu wa katiba hiyo. Na mambo ambayo nimejadilia ya waziri Munya sio Mungu ya kuwa hatuwezi kumjadilia. Sijajadili mambo ambayo inamhusu yeye binafsi, na jadili utekelezaji wa kazi yake kama waziri wa serikali. Na hafanyi kazi ya serikali kama Peter Munya, anafaa afanye kazi ya serikali kwa mujibu wa katiba na sheria zilizowekwa. Na ndio nimetaja mambo ambayo amefanya ambayo ni kinyume cha katiba na cha sheria.
Mheshimiwa Obo.
Asante Bwana Spika. Nataka Mheshimiwa arekebishe. Si haki kumtaja na kutoa uzushi na kusema mambo ambayo hayana maana na kufanya siasa. Yeye ndio anafanya siasa, sio waziri anafanya siasa. Waziri hako hapa kwa Hansard akifanya siasa. Ambapo sisi watu wa Lamu tunajua miraa inapita boda ya Lamu ikenda Somalia, watermelon zetu haziendi. Ni kukosa shukrani. Waziri amefanya kazi kubwa zaidi. Kama ni soko ya miraa, sisi ndio tunashuhudia. Miraa zinapita Lamu, boda imefungwa na inaenda Somalia, ambapo watermelon zetu haziendi. Kisha wanasema bado waziri hajafanya kazi nzuri. Huo ni uzushi na wewe ndio utakufanya siasa. Asante.
Sasa amedhihirisha ya kuwa magendo yafanyika, Bwana Spika, sababu anasema hizo ndizo shida ambazo, Bwana Spika, tunajadili. Kama soko limefungwa na anatuambia merikebu za vuka mpaka kwenda kupeleka miraa, ilhali serikali na msimamo wa serikali ni kuwa bado wanajadiliana mambo ya kufungua.
Member from Vita.
Bwana Spika, ndugu yangu Kimani Ichung'wah ambaye nitatamani hoja zake vile anavyozileta, lakini leo nataka kumnukuu maneno aliyozungumza na naomba anisikie, na ndio yale tunayozungumza. Bwana Spika, ametoa kauli hapa akasema ni kitu gani waziri anasema na yeye tayari ni waziri. Sasa wache ule waziri ambaye anaajiriwa na kufutwa na kalamu. Ni kitu gani yule ambaye kwamba ni naibu wa rais ambaye kikatiba hawezi kufutwa anaweza kukifanya kesho, leo kikawa kimemshinda kukifuata? Tusiwe Bwana Spika, tusiwe ni wenye ngozi mbili. Mbele za watu tuwe na ngozi ya kondoo, mbele ya wengine tuwe na ngozi za chui na fisi. Mbele za watu museme tutarekebisha hivi na hivi, ila hali mulikuwa katika serikali miaka yote, sio miezi miwili kabla kura ndo iwe ni ghafla watu wamekuwa malaika. Mimi nakubaliana na wewe hoja yako ya kuwa ikiwa ni waziri hukufanya siku zote, ni lipi utalisema utalifanya kesho, na ikiwa ni naibu wa rais miaka 9 hukuweza kuyatekeleza, utayatekeleza gani yale ambayo kwamba utawatekeleza? Acheni siasa za abrakadabra bwana.
Mheshimiwa Spika, nakubaliana kabisa na ndugu yangu anayewania kiti cha ugavana cha Mombasa na namtakia heri. Lakini nafikiri hakunisikiza, sababu hoja yangu ilikuwa waziri ambaye ameteuliwa kwa wakati huu na kuna yule aliyemteua na amempea mamlaka yote ya kutekeleza yale anayowaambia watu kwa mikutano ya kisiasa atatekeleza. Asipotuambia ya kuwa aliyemteua saa hii kuna mambo ambayo amemkataza kufanya kusaidia wakulima, hawezi tuambia kesho akiteuliwa na mwingine ndio ataweza kutekeleza. Kwa naibu wa rais, Bwana Spika, Mheshimiwa Abdul Samad anaelewa. Ukiangalia utaratibu uliokuwa jana pale kwa sherehe ya madaraka, utajua naibu wa rais alifutwa kazi kinyume cha sheria pia na rais mwenyewe aliyekuwa na tabia ya madharau mengi sana jana. Kwa hivyo bwana Spika, nataka nimjulishe na mfahamishe Mheshimiwa Abdul Samad ajue ya kuwa hata kama naibu wa rais kikatiba hawezi futwa kazi na rais, rais kwa mtindo na kwa tabia zake ashamfuta naibu wa rais kazi. Ni vile tu katiba inamlinda naibu wa rais. Rais amemkataza naibu wake kufanya kazi ya Wakenya kwa kumhujumu na kumfanya madharau na ofisi yake madharau, akatoa kazi zote zilizokuwa kwa ofisi ya naibu wa rais akapeleka kwa ofisi yake rais mwenyewe. Kwa hivyo kama kuna mtu ambaye amefeili, mwenye ameshindwa kufanya kazi ya utekelezaji wa kusaidia wakulima wa miraa, kama sio Munya basi ni yule aliyemteua. Na ndio nasema Munya kama hawezi tuambia Uhuru hata rais mwenyewe ndiye amemkataza, atuambie ya kuwa mwenye anafanyia kampeni sasa ndiye atamwezesha. Lakini hoja kubwa na Spika ni ya kuwa waziri kikatiba, waziri wa serikali hafai kuwa akiendesha siasa, na hiyo ni katiba. Hao mawaziri tumewapitisha kwa hili bunge wakiteuliwa na rais kama waziri, na kuna ule utaratibu wa sheria na kikatiba ambao wanafaa kufuata. Na ndio yangu haikuwa kumjadili Bwana Munya. Bwana Munya ni mtu mdogo sana kujadiliwa na bunge. Tulimjadili wakati tulikuwa nampiga msasa ateuliwe kama waziri. Chairman wa Agriculture Bwana Tirena kwa hapa atakwambia tabu na shida zilizo na wakulima, mambo ya mbolea huko bonde la Ufa kaskazini, ni mambo ambayo huyu waziri pia amefeli kama waziri. Na ni venye tu Bwana Spika, hakuna wakati hii wiki mbili imebaki ya kupiga mzaza na kufuta Naomba Wakenya tufute huyo waziri na kufuta hii serikali na wale wanaowafanyia kampeni.
Now, the issue, just to remind you, the issue arose out of a comment by way of appreciation from the member for Igembe South upon the report that has been presented by the chair of the Agriculture Committee about the statement that he had sought about the Mira markets and things like those. Just because I can see a few of you are walking in and beginning to get excited, you think that what you found there, there is no motion. So all of you are putting interventions. I hope it's not on this. Is it on this? If it's on this one, next order. Next order. Next order. Next order. The House must do business, not...
Order number 8, procedural motion, extension of sitting time.
Majority Whip.
Thank you, Honorable Speaker. Honorable Speaker, pursuant to the provisions of Standing Order 33A, this House orders that, should the time appointed for adjournment of the House today be reached before conclusion of business appearing under Order number 17 on today's order paper, the sitting of the House shall stand extended until the conclusion of the said business. Honorable Speaker, as the House may be aware or is aware, we have a lot of work to do. We have a lot of commitment. Again, as Honorable Speaker, the time frame which we are likely to rise the House due to Sinadie leave. Therefore, Honorable Speaker, it's important now that we just have 3 days beyond today. It's good that the House concludes as per the order paper to order number 17, so that we beat the time, Honorable Speaker. I wish to move and ask the Honorable Ishungwa to second.
I second. No, on record. On record.
I second.
No. Honourable members, let me propose a question. No, you can't ask before we have proposed. I propose a question. It is that pursuant to the provision standing under 30, subsection 3, paragraph A, this House orders that should the time appointed for adjournment of the House today be reached before conclusion of business appearing as order number 17 on today's order paper, the sitting of the House shall stand extended until conclusion of the said business. Honorable Abdul.
Honorable Speaker, I seek your indulgence with a lot of humility. With a lot of humility, I repeat again. I seek your indulgence, Honorable Speaker, considering that the Public Investment Committee has 3 reports equally. I seek your indulgence that the motion that the the Minority Whip has requested for to be extended not up to order number 17, but rather to the order that reaches up to PIC. In that way, Honorable Speaker, it will enable us to be able to also finalize the other. It is a humble request, Honorable Speaker.
But you see, the way to go about that is to propose an amendment. Where there not be other people to second, I call upon the mover to. No, Honour members, let me put the question. That pursuant to the provision standing under number 30, subsection 3, paragraph A, This House orders that should the time appointed for adjournment of the House today be reached before conclusion of business appearing as order number 17 on today's order paper, the sitting of the House shall stand extended until conclusion of the business. With as many as that opinion say aye. Many of contrary opinion say nay. The ayes have it. Sorry. Come yeah. Oh, next order. Next order.
Order number 15, Committee of the Whole House.
Yes.
This is the schedule. That's the schedule. This is the procedure. And orders without amendments.
Honorable Rachel Nyamae, we are now in Committee of the Whole House to consider amendments to the standing orders. And I have reliable information that you intend to be back in the 13th Parliament. It might be useful that you prepare what you are going to use. I am aware that several of those other members walking away. And members,
Standing Order 1.
I propose that standing order number 1 be part of the standing orders. There is no amendment. So I put the question, which is that the standing order number 1 be part of the standing orders. With as many as that opinion say aye. As many of contrary opinion say nay. The ayes have it. Yeah.
Speaker, just like the way we deal with the bills at the Committee of the Whole House, now that there are no amendments to these standing orders, why can't you read in about 5 of them, we put the question, another 5, we put the question to move faster? Because there's nobody who has an amendment.
There are several. The reason is because there are several proposed amendments.
Okay.
It's not just that number 1.
By members.
Number 1, standing order number 1 has no proposed amendments.
By the committee.
Yeah.
Okay, Speaker. Yeah, I forgot. Yeah, the committee has amendments.
Yes.
Thank you.
About number 2 itself.
Standing Order number 2A.
I propose that standing order number 2A be part of the standing orders. There are no amendments proposed, and I put the question, which is that standing order 2A be part of the standing orders. As many as that opinion say aye. As many as the contrary opinion say nay. The ayes have it.
Standing Order number 3.
I propose that standing order number 3 be part of the standing orders. That one has an amendment?
Yes, Mr. Chairman. I'm sorry to call you chairman today. You are ordinarily a speaker. This basically is on the proceedings of a new August House, and it is actually the order of precedence in terms of taking oath and so forth. So the justification is to recast and rearrange the provisions of the logical flow to put into consideration the order of precedence to be observed in the National Assembly as provided under Article 108.4 of the Constitution. Thank you.
Well, I think I hope members have followed up. So I propose a question, which is that standing order number 3 be amended as proposed by the committee, as per the order paper. I put the question, is that standing order number 3 be amended as proposed in the order paper. With as many as that opinion say aye, many of the contrary opinion say nay. The ayes have it. I now put the question, which is that standing order number 3 be part of the bill. Will as many as that opinion say aye? Aye. As many as the contrary opinion say nay. The ayes have it.
Standing order number 4.
Mr. Chairman, I beg to move that the standing order number 4 be amended as per the order paper. This is basically on elections of the Speaker after a general election. The justification of this is to recast the title of the standing order for logical flow of provisions and to delete paragraph 2 and 3 for the introduction of in the appropriate standing orders that deal with vacancy of the Speaker. Because in the bill, in the standing order, there are others that deal specifically with that.
I propose that standing order number 4 be amended as per the order paper. I put the question, which is that standing order number 4 be amended as proposed in the order paper. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I never put the question, which is that standing order number 4 as amended be part of the standing orders. Will as many as that opinion say aye? Will as many as contrary opinion say nay? The ayes have it.
Standing order number 5.
I propose that standing order number 5 be as there's an amendment.
Yes. Yes, Mr. Chair, there is an amendment to this one. Yeah. So, Mr. Chair, I beg to move that the standing order number 5 be amended as per the order paper. This is to require the clerk to appoint a nomination day and designate a place and period within which candidates may present their nomination papers for election of the Speaker, so that it is different from what happened before, where they bring it to the clerk's office. We want to make it more transparent and open. Thank you.
I propose the question, which is that the standing order be amended as proposed. I put the question, which is that standing order number 5 be amended as proposed in the order paper. As many as that opinion say aye. Aye. Many of the opinion say nay. The ayes have it. I now put the question, which is that the standing order number 5, as amended, be part of the standing orders. Will as many as that opinion say aye? As many of the opinion say nay? The ayes have it.
Standing order number 6.
Propose that standing order number 6 be part of the standing orders.
Yes, Chair. I propose that. I beg to move that standing order number 6 be amended as per the order paper. This is basically on issues of election, and the standing order 10 now requires the clerk to maintain custody of ballot papers after elections, as ballot may also be required in case of a dispute. So he keeps them so that if there is any person like what happened this term wants to go to court, there will be ballot papers to prove.
I propose a question, which is that standing order number 6 be amended as proposed on the order paper. Honorable Duale.
Speaker, this is a very, very good amendment. The House must set the record straight and show an example. You know, there are people in this country who always go to court. So in the event one of them applies for the position of a Speaker and they want to go to court, I think even the custody of those ballot papers, both spoiled, and the numbers that have been casted must be kept in a very safe, strong room, designated by the clerk. I support.
I put the question, is that standing order number 6 be amended as per the order paper. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I now put the question, which is that standing order number 6, as amended, be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order 7.
Propose that standing order number 7 be part of the bill. There is no amendment. I put the question, which is that standing order number 7 be part of the standing orders. As many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order number 8.
Propose that standing order number 8 be part of the standing orders. Mover.
Chair, I beg to move that standing order number 8 be amended as per the order paper, still on elections. And for consistency, the word printed is used in reference to ballot papers, still on the elections of the Speaker.
I put the question. I put the question, which is that standing order number 8 as amended be amended as proposed by the chair. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the question globally that standing order number 8 as amended be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order number 9.
I propose that standing order number 9 be part of the bill, be part of the standing orders. There's no amendment. I therefore put the question, which is that standing order number 9 be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order number 10.
I propose that standing order number 10 be part of the standing orders. Mover.
I beg to move that standing order number 10 be amended as proposed in the order paper. This is still on elections of the Speaker, and this is to require the clerk, like the Honorable Dwala has just indicated a few minutes ago, to retain custody of any spoiled papers after election of a Speaker.
I propose a question, which is that standing order number 10 be amended as proposed on the order paper. I put the question, which is that standing order number 10 as amended be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the question, which is that the standing order number 10 as amended be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing orders number 11 and 12.
I propose that standing orders 11 and 12 be part of the standing orders. It's no amendment. I therefore put the question, which is that standing order numbers 11 and 12 be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order number 12A.
I propose that standing order number 12A be part of the standing orders.
Amended as proposed in the order paper. This is basically on issues of vacancy of office of the Speaker. This is to align the standing orders with provisions of Article 106 of the Constitution.
I propose that standing order number 12A be amended as proposed on the order paper. There being no debate, I put the question, which is that standing order number 12A be amended as proposed on the order paper. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the global question, which is that standing order number 12A as amended be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing orders 12B, 13, 14, and 15.
I propose that standing orders 12B, 13, 14, and 15 be part of the standing orders. There being no amendment, I put the question, which is that standing orders 12B, 13, 14, and 15 be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order 16.
I propose that standing order number 16 be part of the standing orders. Mover.
19. I beg to move that standing order number 16 be amended as per the order paper. This is issues to do with panel, where there is an increase of panel members from 4 to 6. This is to increase the members, and the justification is just to make them a bit more efficient, and also that they are not overwhelmed like has happened in this term.
I propose the question, which is that standing order number 16 be amended as per the order paper. There being no debate, I put the question, which is that standing order number 16 be amended as per the order paper. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the global question, which is that standing order number 16 as amended to be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing orders 17 and 18.
I propose that standing orders 17 and 18 be part of the standing orders. It's now an amendment proposed. I therefore put the question, which is that standing orders 17 and 18 be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order number 19.
I propose that standing order number 19 be part of the standing orders. It's an amendment.
Mr. Chair, I beg to move that standing order number 19 be amended as per the order paper, and I hope the Honorable Duale is listening to this, because these are some of the proposals that he himself initiated. It's actually on issues of party leader and order of precedence. The justification is to establish the offices of leader, majority, and minority leader, and prescribe the order of precedence in the House in line with Article 108 of the Constitution, and also to require the clerk to facilitate the discharge of House business by the two leaders on behalf of the majority and minority parties.
I propose the question, which is that standing order number 19 be amended as per the order paper. Honorable Duale.
Speaker, as the first occupant of this office, and of course with many years, in fact the most important thing, the President is in Article 108, but it is now giving the standing orders the Speaker to facilitate, in accordance with other jurisdiction, that we have, our coalition caucuses, specific rooms for the coalition. If the party leadership wants to meet, if their party leader wants to come to the House, this gives the Speaker room as the chair of the Parliamentary Service Commission to even create a certain budget line, so that under the presidential system of parliamentary system, presidential system that we are used to, parties and its leadership get very strong positions. And before, the speakers, as our chair for PAC, was handcuffed. But I think with this now put in standing order, the speaker can support both the leader of majority and the leader of minority and their caucuses. I support.
There being no other contribution, I wish to put the question, which is that standing order number 19 be amended as per the order paper. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it. Put the global question, which is that standing order number 19 as amended be part of the standing orders. Will as many as of that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing order number 20.
I propose that standing order number 20 be part of the standing orders. Mover.
I beg to move, Mr. Chairman, that standing order number 20 be amended as proposed in the order paper. This again another thought from the Honorable Duale. It's basically on issues of elections, removal of party minority leader of the minority and deputy leader of minority parties, And the justification is to enhance the process of elections and removal from office of the leader and deputy leader of the minority party. A member seeking to remove the leader and deputy leader shall file a motion with the party supported by at least 1/4 of the members of the party. And when communicating the decision of the removal of the deputy, the leader or deputy, the whip must attach minutes of the meetings and names and signatures of members who attended and resolved the removal of the leader or deputy.
I propose a question, which is that starting on number 20 be amended as per the order paper. Honorable Duale.
Speaker, I think this is good for everybody, just like the way we have the fair administrative justice and even procedure of even removing a member from a committee. I think the leadership of this House should not be subjected to removal from office in funerals and in public rallies under the whims of some people who sit very late in the night under the influence of certain products. The House must have, yes, the House must have due process, that if you want to remove Honorable Jude Jomo, you must give him due process. I'm talking as a victim. Up to today, there are certain signatures I'm yet to see, but of course, when my book comes out, Mr. Speaker, I'm talking about that period. People will say, but we must protect the future leaders. It might not be me, it might be somebody else, but a due process in law, that even the Speaker, even how we submit the list to the Speaker, the minutes, the signatures must be documented in our standing order. I support.
Any other comment? Honorable Jungwa.
Mike. Thank you, Honorable Chair. And Honorable Chair also rise to support this particular amendment. It is indeed a very progressive amendment. And as a ranking member, the Honorable Member for Garissa Township has said, it is also in pursuit of the Fair Administrative Justice Act and the provisions of the article in terms of fair administrative processes, that any person being removed from office ought to be given a fair chance to be heard and to know what is being accused of. And I honestly sympathize with the Honorable Aden Duale, because I was a member of that party, the party that the leader of majority then, the Honorable Aden Duale, served as leader of majority. And it is true, Honorable Speaker and Chair of this committee, that the removal, for instance, of the Honorable Aden Duale as leader of majority was extremely unprocedural. There was no party caucus that sat anywhere, not a parliamentary group meeting, not any party organ, Honorable Speaker, that sat to even listen to accusations against the Honorable Duale. And he served diligently the party that he was having then, Honorable Speaker. But he was removed in a very unprocedural way, and it's only right that in future we protect future leaders of minority and leaders of majority. You've also seen, Honorable Speaker, the case that we had of the Honorable Aisha Jumwa in the Parliamentary Service Commission that you serve in, attempt by a political party without following due process, attempting to remove her. And it's only fair then that we give both the leader of minority and the leader of majority some protection under our own standing orders, that members have a say, because these leaders are leaders of the House. They don't lead their political parties in the House, they lead members of parliament in the House. And therefore it is only right that if any one of them is to be removed, whether from the minority or from majority, that the members they are leading have a say as to the person they want to lead them. With that, I support.
Any other? Honorable Martin Owino Waters.
What, Chief?
Martin.
Thank you, Mr. Speaker.
Member Bondiwa.
Thank you so much. I want to add my voice to this. Indeed, fairness is paramount at all levels, not only in leadership, but at all levels. But I wanted to be in record that this is for future prosperity and not coming or driven by victims. Because if we put it like that, it's a reactionary instead of being precautionary. So I think this is a good thing. Just wondering, Mr. Speaker, why it is a quarter and not a third? Because even if you want to play the vendetta, a quarter is still a small amount of people just to gather signature and get you out or bring it here. So, but I support.
Well, I'm sure many of you may recall, towards the tail end, those who were in the 11th Parliament, towards the tail end of that Parliament, that's when we came up with the process that is in Articles 1, in Standing Orders 173 and 176, all through to 176. And I do recall that even getting that passed through here was problematic, even to notify a member. So I think it's good, it's incremental. Honorable Owino, it's incremental, and I think it is good for us. We are doing these standing orders for the 13th Parliament. They are not to be applied in the 12th Parliament. It's for that reason that, in fact, I'm here. It's because they are not good. They are not meant to be used by this Parliament. It's for the future Parliament, and maybe they could find it necessary to increase the threshold. So much the better. They could even come up with 50%. But I think it's good to start somewhere. Yes. Honorable Nyamai.
Thank you, Honorable Speaker. I agree with the amendment. But Honorable Speaker, I also have reservations on the justification that was given by the Honorable Duale and the Honorable Ishungwa. And I would like to say that it is important that we look at this as an amendment to improve work, implementation of work in the future Parliament, that is in the 13th Parliament, and also ensure that we do not look at it as a correction of what has already passed, because that has already passed. I think that justification is not acceptable, but he has a right to say that. Honorable Speaker, I would like to say that this amendment is good because it also takes care of party loyalty. Honorable Speaker, the reason as to why people become majority and minority leaders in this House is because they have been loyal to a party. So party loyalty is paramount, and this the standing order that we have amended today takes care of party loyalty. So there is no way someone can be a leader of majority, leader of minority, without being loyal to that party. So thank you, Honorable Speaker.
Yes, what? I hope it's a point of order that she has said, which is out of order, not a point of argument.
No, Mr. Speaker, I think Honorable Nyamai is out of order. Mr. Speaker, you must correct that there's a tendency that there are people who come to the House and contribute based on what some other members of Parliament have said. We have our own justification, and we have all the right. So you also justify, but don't use it. In fact, Mr. Speaker, we make laws after using them, but not just because I spoke. You come on it's out of order to criticize my free thought, my free conscience. Think for yourself.
No, it is not out of order to criticize. It is okay to criticize, but she still supports. But what we provided for in Standing Order 173, that before a member is de-whipped, that they be notified. For a member, you want to de-whip a member from a committee. Surely, this is an elected member or specially elected. You have put them in a committee. Should the party that appointed you there feel that they want to remove you? It's only fair that they tell you. Please, it is not good to just wake up or sit in some small room is it called Blue Room or some other, in a Norfolk Hotel, and then somebody is removed. It's not good because you also cause unnecessary tension to that member's immediate family and friends and relatives. I think it's all we are trying to do. Remember, it is this same house which passed the Fair Administrative Action to implement the constitutional provisions on fair administrative justice. So I think all we are trying to do is to try and clean up our standing orders to make it that much easier, so that you could say this over the weekend. When you come here, I cannot see you on the basis of what you said over the weekend. You are not serving. That time you are dealing with villagers, or you could be in your church, in your mosque. That should not bother me. Whatever it is, you could even have said it about me. But because you said it there, I should not hold it against you. This is a culture which we are trying to inculcate among members and the leadership. So I think it's okay for the Honorable Nyamai to criticize, but nevertheless support. Honorable Nyoro, Dindi Nyoro.
Thank you very much, Mr. Speaker. And I rise to support, because, Mr. Speaker, this amendment goes along into having a person being heard before they are condemned. And, Mr. Speaker, also, it runs contrary to the politics of personality cult, where a political party is an individual and they can do anything they want arbitrarily. Mr. Speaker, this does not just streamline the workings of this House, but it also enhances our democracy. Democracy is an institution, Mr. Speaker, other than democracy that is based on the whims of party leaders, Mr. Speaker. And by the way, this also protects even the party leaders themselves, Mr. Speaker, because sometimes you may be wrong, you may be powerful but wrong, Mr. Speaker. You may need a person who is less powerful to correct you. And in the long run, their guidance may actually be for the benefit of the more powerful person. And therefore, Mr. Speaker, I support, because, Mr. Speaker, this diminishes the politics of hero worshipping and personality cults, and especially of party leaders.
Very well. Honourable members, now I put the question, which is that standing order number 20 be amended as per the order paper. Will as many as of that opinion say aye? As many of contrary opinion say nay? The ayes have it. Put the global question, which is that standing order number 20, as amended, be part of the standing orders. Will as many as of that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing orders number 21, 22, 23, 24, 25, 25A, 26, 27, and 28.
I propose the question, which is that standing orders 21, 22, 23, 24, 25, 25A, 26, 27, and 28 be part of the standing orders. There are no amendments proposed. I therefore put the question, which is that standing orders 21, 22, 23, 24, 25, 25A, 26, 27, and 28 be part of the standing orders. Will as many as sought opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order 29.
I propose that standing order number 29 be part of the standing orders. Mover.
Mr. Chair, thank you. I beg to move that standing order number 29 be amended as per the standing order, as by the order paper, to provide for a session in which special sittings that is held between two ordinary sessions of the House will fall in. Fairly straightforward, Mr. Chair.
Well, I propose that standing order number 29 be amended as proposed on the order paper. I put the question, is that standing order number 29 be amended as per the order paper. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it. I put the global question, which is that standing order number 29 as amended be part of the standing orders. Will as many as of that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing orders 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, and 42.
I propose the question, which is that standing orders 30, 31, 32, 33, 34, 35, 36, 37, 38, 39, 40, 41, and 42 be part of the standing orders. No amendments proposed. I therefore put the question, which is the standing orders as read out, be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order 42A.
Proposed that standing order 42A be part of the standing orders. Mover.
Thank you, Chair. I propose that I beg to move that standing order number 42A be amended as per the order paper. This is an extremely interesting bit, Mr. Chair, where there is an anticipation of a government that is which has a minority in parliament, but still forming government. The justification of this amendment is to provide for instances where the leader of minority party, to undertake duties relating to questions where minority party is the party forming national government. If you look at maybe 2007, I think this kind of scenario could easily have unfolded. That is the NAC and the other party.
I propose that standing order 42A be amended as per the order paper. Honorable Duale.
Speaker, I support, even though it's very unlikely to happen, because Kenya Kwanza will flood this house in the 13th Parliament, inshallah. But this happened in other jurisdictions. It happened during, I think, the second term of President Obama, where he had a minority, and in one time, Nancy Pelosi was the majority leader, the next time she was the minority leader. So these are things that can happen in a presidential system, and I support the chair of the committee amendment.
Very well. I put the, Honorable Makali Mulu. Sorry.
It seems to be not working.
Yeah, thank you, Honorable Speaker. Honorable Speaker, I also want to support this amendment, and I want to give my own example of my own county, where actually the governor is the governor, but in the assembly, she has a minority. So the minority in the assembly is the government, the other side. So I think it makes a lot of sense to have this in the standing orders. I support.
Yeah, I think it's, honourable members, you can imagine we have very many independent presidential candidates. Supposing, God forbid, any of them were to win. I guardedly said, God forbid. Honorable Nyoro.
Thank you very much, Mr. Speaker. I also support, Mr. Speaker, because we have been through the same in 2007. However, as the former majority leader stated, I actually don't see this happening in these current elections, Mr. Speaker, because all projections are that the coalition that is going to form government, Mr. Speaker, will not just have a majority, but have a supermajority in this parliament, Mr. Speaker. But it's good for this House to be proactive, Mr. Speaker, and make laws even for the future, other than to be caught off guard like we were in 2007. I also plead that even the other county governments, Mr. Speaker, can borrow from this National Assembly, because this problem is more prevalent in county assemblies, Mr. Speaker, where you have governors who are leading minorities in terms of their county assemblies. And therefore, I hope they are learning, and they should cascade the same to the county assemblies.
True. And of course, if one were to look at contemporary jurisdictions, the example given by the Honorable Duale is valid. But actually, in the same jurisdiction in America, if you recall, there was a speaker by the name Newt Gingrich, a Republican. The reason why he kept harassing President Bill Clinton is because Bill Clinton's party, the Democrats, are a minority in the House. That's the only way that in the American system, which is what we copied in what 2010 Constitution, that the only time that you have a minority, you have a speaker from your party is when your party is in government. But because they do midterms, you have midterm elections after 2 years, you could easily lose your majority, and then you go and sit on the other side. I put the question, which is that standing order number 42A be amended as per the order paper. Will as many as that opinion say aye? Will as many as contrary opinion say nay? The ayes have it. Put the global question, which is that standing order 42A as amended be part of the standing orders. Will as many as of that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 42B.
The proposal that Standing Order 42B be part of the standing orders. Mover.
Thank you, Chair. I beg to move that Standing Order 42B be amended as proposed in the order paper. This is a very common problem that we've had in this term, where on issues of asking questions by members delegating other members to ask questions on their behalf. Sometimes, Honorable Chair, two members rise at the same time and both claim to be having instructions to ask questions on behalf of a member who is not here. So what we are trying to do, Chair, using this standing order, is to allow a member to formally nominate another to ask a question on his or her behalf.
I propose that Standing Order 42B be amended as proposed on the order paper. I put the question, is that, sorry? I put the question, which is that Standing Order 42B be amended as per the order paper. Will as many as that opinion say aye? Many of contrary opinion say nay. The ayes have it. Put the global question, which is that Standing Order 42B as amended be part of the standing orders. Will as many as that opinion say aye? Many of contrary opinion say nay. The ayes have it.
Standing Orders 42C, 42D, and 42E.
Propose that Standing Orders 42C, 42D, and 42E be part of the standing orders. There being no amendments, I put the question, which is that Standing Orders 42C, 42D, and 42E be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 42F.
Propose that Standing Order number 42F be part of the standing orders. Mover.
Chair, I beg to move that the Standing Order 42F be amended as per the order paper. This is to require the committees to make statements on questions and reduce the instances of members having to query, which has been very common, the status of their questions on the floor, because there will be time for them, for chairs to submit progress on those questions. Thank you.
I propose that I put the question, which is that Standing Order number 42F be amended as per the order paper. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it. Put the global question, which is that Standing Order 42F as amended be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 43.
Propose that Standing Order 43 be part of the standing orders. There being no amendment, I put the question, is that Standing Order number 43 be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 44.
The proposal Standing Order 44 be part of the standing orders. Mover.
I beg to move that Standing Order 44 be amended as per the order paper, the justification being to allow the chairpersons of committee to make statements relating to mandate of their committees, also to introduce reintroduce Standing Order number 84 on personal statements for logical flow of standing orders, and also to provide timelines of 21 days or such shorter period as the Speaker may direct for statements requested by members from committees. Thank you.
I propose a question, which is that Standing Order 44 be amended as per the order paper. No comment. I put the question, which is that Standing Order 44 be amended as per the order paper. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it. Put the global question, which is that Standing Order 44 as amended be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 45.
Propose that Standing Order 45 be part of the standing orders. Mover.
I beg to move that Standing Order number 45 be amended as per the order paper. This is basically on public appointments, and this is to increase the period of approval of public appointments from 14 to 21 days, and also to empower the Speaker to commit appointments to other relevant committees of the House in exceptional circumstances. So that is not necessarily departmental committees, could be other relevant committees.
I propose that standing order number 45 be amended as per the order paper. Any comment? No comment. Honorable Shamala. Yes, please.
Thank you, Chair. I'm just curious to understand why the time is being enhanced from 14 to 21 days. It seems rather excessive, but I would like to understand the rationale.
I wonder whether the chair has heard you.
Well, Mr. Chair, that one looked to me a fairly straightforward one. We have been doing some of these things and sometimes we run short of time. And this is basically just to give good time so that we do not have to rush. Some, deliberations that we do that are done at the appointments committee are really severely narrowed down because of the lack of time. So let's give it's a question of actually improvement on questions of appointments and other such things.
Dr. Makalimul.
Yeah, Mr. Speaker, I think this amendment is quite important for this House because in the past, actually, especially this season, the 11th Parliament, no, the 12th, we have seen a number of committee chairs requesting for additional time to be able to sort out some of these issues. And where there is no time, then they have to rush because it's either you do it within 14 days or you must then. So I think 21 days makes a lot of sense so that we allow committees enough time to really do justice to these kind of activities. Thank you.
We are adopting a system of the US and we must totally agree with as same jurisdiction. Even approval of ambassadors in the US, forget about ministers, takes about 6 months. I mean, the Kenyan ambassador, the nominee for Kenya, I think was approved just about 3 weeks ago. Speaker, this House needs to have more time to do serious, diligent work. Even the people who give affidavits need to be given an opportunity to appear before the committee. Even when EACC contradicts, sends 2 different letters, the officials of that body or help must come before the committee. So I totally agree, and I served with you in the appointment committee. I think there's a lot of rush, just like we are asking for more time for the Supreme Court to deal with the presidential petitions. It's because of the matter. So I think I really support. In fact, we should have said it a month. Because the House should not be at the mercy of the executive. The House can even say that we are going to approve and go to. It's like, Mr. Speaker, I saw the other day a commissioner of EACC was being approved, and he attended an interview virtually. That has never happened. Yeah, it's not permitted in our standing orders. It is not permitted in our standing orders. And you know what I'm talking? You had your chance, just shut up. Thank you, Mr. Speaker, I support.
Honorable Gishimo. The Public Appointments Parliamentary Approval Act to increase the period from the initial 14 days to 28. Approval. Public Appointments Parliamentary Approval Act of 2012. Remember, at some point when it was realized that you see, the law is coached in such a way that if you have not approved or expressed yourself as a House, one or other, on the nominees, they are deemed to have been approved. And I think it then makes absolute nonsense of requiring the House to approve if the House is being hurried and is not able to really, go into details. I think. But anyway, honourable members, let me put the question, which is that standing order number 45 be amended as per the order paper. Will as many as of that opinion say aye? Will as many as of the contrary opinion say nay? The ayes have it. Put the global question, which is that standing order 45 as amended be part of the standing orders. Will as many as of that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing orders 46, 47, 48, 49, 50, and 51.
I propose a question, which is that standing orders 46 through to 51 be part of the standing orders. There being no amendments, I put the question, which is that standing orders 46 through to 51 be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing order 52.
Propose that standing order 52 be part of the standing orders. Move on.
I thank you, Chair. I move that standing order 52 be amended as per the order paper. This is to include an exceptional motion of tributes of the House as a motion that may be moved without notice. This is on issues of notice on moving of motions.
Yeah, I propose the question, which is that standing order 52 be amended as per the order paper. Honorable Gitonga Murugara.
Thank you, Mr. Speaker. Mr. Speaker, I think this is timely. Previously, you've been using your discretion to just give us permission to pay tributes to the affected persons. But now that we are going to have a standing order anchored in our rules, we will be able to move upon standing for you to give us a permission to pay tributes to specific persons. This is timely.
Very well. I put the question, which is that standing order number 52 be amended as per the order paper. Will as many as other opinion say aye? As many of the contrary opinion say nay? The ayes have it. Put the global question, which is that standing order 52 as amended be part of the standing orders. Will as many as of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it.
Standing orders 53, 54, 55, 56, 57, 58, 59, 60, and 61.
I propose the question, which is that standing orders 53 through to 61 be part of the standing orders. There being no proposed amendments, I put the question, is that standing orders 53 through to 61 be part of the standing orders. Will as many as of that opinion say aye? Will as many as the contrary opinion say nay? The ayes have it.
Standing order 62.
I propose that standing order 62 be part of the standing orders. Mover.
Chair, I beg to move that standing order 62 be amended as per the order paper. This is to allow the Speaker to designate a further date on which a vote may be taken in instances where the Constitution requires a fixed majority of members of the House.
I propose a question, which is that standing order 62 be amended as per the order paper. I put the question, which is that standing order 62 be amended as per the order paper. Will as many as for that opinion say aye? As many as the contrary opinion say nay? I put the global question, which is that standing order 62 as amended be part of the standing orders. Will as many as of that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing order 63, 64, 65, 66, 67, 68, 69, 70, 71, 72, 73, 74, 75, 76, 77, 78, 79, 80, 81, 82, 82A, 82B, 80, and 82C.
I propose the question. I propose the question, which is that standing orders 63 through to 82C be part of the standing orders. There being no proposed amendments, I put the question, which is that standing orders 63 through to 62 to 82C be part of the standing orders. Will as many as that opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing order 83.
Propose that standing order 83 be part of the standing orders. Mover.
Thank you, Chair. I beg to move that standing order number 83 be amended as per the order paper. This is basically an issue that has arisen out of use of this new process of electronic gadgets and so forth, so that the Speaker so that to require a member to rise in his or her place when raising a point of order. This is like what used to happen before. I know the members who are here a little earlier, myself and you, Mr. Chair, and others, probably Duale at the beginning of his term when he joined here, and Naomi Shaban, who is my neighbor just here. Just that issue of raising it gives the Speaker a situation where he can be able to differentiate between the points of interventions.
Honourable members, I propose a question which is that standing order number 83 be amended as per the order paper. Honourable Duale.
Speaker, I oppose. Because we left analog, and I served in the 10th Parliament, you served the Speaker in the 9th Parliament. If you start allowing people to stand here, you'll see crowds standing. Let us use electronic, the intervention, the speakers and the deputy speaker and the panels will agree. I really want the chair, my respectable chair and deputy speaker, to withdraw that, because we are going back to the old system. Let's use the gadgets which Parliament has paid for an investment. Otherwise, there are people here, they will be standing the whole day.
Honorable Wanga.
Honorable Chair, let me agree with Honorable Duale. We move forward. We never move backward. And the intervention system has worked, except for when you don't have your card. And I think the discipline of having to have cards, we moved from the cards, then we moved to the iPads. We no longer have papers here. Then now we should be moving forward. He should be telling us maybe there's some robot that will be flying around. You know, we have to move forward. But this thing of taking us back to stand, sit, there'll be too much exercise around here. And the Speaker will not be able to tell who intervened before the other, unless now the Speaker has to calculate the rate at which you stand or sit. Thank you, Honorable Speaker. I oppose.
Let's hear the Deputy Speaker as a chair, as a mover, explain something.
You know, Mr. Chair, I'm a bit surprised, especially by Honorable Duale, because many times, and this is a question that has arisen out of use. Number one, if you look at the slot there, it is about 4 names that appear. Many times the chairs who sit there or in the main speaker seat are accused of not seeing members, and yet the gadget takes only 4 members at a go. Now, it becomes extremely difficult because sometimes a member wants to raise a point of order, another person sometimes, and many of these members do all the time, put the slot there for you to recognize them for a contribution later. Now, this one, and by the way, it is not analog, because if you go to the House of Commons, it is happening. And by the way, this does not really affect very much the Presidium. It affects these members. Because many times the complaint has been that, Mr. Speaker, I put my intervention slot, you are not seeing me. But if there are 10, and sometimes there are 10 or even 20 when it's a matter which is very serious, it's not very easy for the Presidium to recognize. Really, it is up to you, members. If you choose that you want to go a direction, then also don't have your cake and eat it. Don't ever accuse the Presidium of not seeing or identifying you. And by the way, in my thinking, you have nothing to lose. We might have something that is that used to be used a long time ago. If it was not as bad, sometimes it's not necessary to fix it. So we are fixing this one because we have seen. And by the way, the honorable members, next term, and I can see most of the ones who are speaking, of course, other than the honorable lady at the end there, are still aspiring to come back here. And it looks like they have extremely good chances, including myself. We wouldn't want a situation where you will be able to accuse the Presidium when they are, because it could have been seen. For example, if members are rising all over, you are able even to see the mood sometimes. So let us be careful, Mr. Speaker, Mr. Chair, and I really want to wish the members would go with this. But if they indeed have a major problem, there is something I can do to cure it.
Honorable Makali Mulu, I think they are quite the number. Honorable Makali Mulu.
You know, Mr. Speaker, the challenge with this amendment is that when you are seated there, how do you determine the person who raises up first? So that I'm on my side here, Wanga is there, the other one is there, and we all stand up. How do you determine who to start with? For me, I think in terms of order, the system we are using makes a lot of sense. So this is something I would propose that we really don't adapt it. Thank you, Honorable Speaker.
Well, sorry. The chair is maybe let's hear the member that will South before you inform the chair, because he spoke about standing, and I was just wondering how the Honorable Tim Wanyonyi and the Honorable Danita Gatti would now therefore stand, but
Mr. Speaker, you have actually just taken the words out of my mouth, because it would be calling for us to be gesturing to the Presidium. And Mr. Speaker, I do agree very much with the Chair of Finance Committee that we should actually be proceeding, not regressing, Mr. Speaker. That if we are proposing any change, it should be moving beyond the computers we have here to now find out how we can incorporate artificial intelligence to assist the person on the Presidium to be able to identify. Because there are two things, Mr. Speaker. One, it is about showing interest. And secondly, it is in the order with which you show interest. Because if the order is disorganized, Mr. Speaker, the person at the Presidium will be using their own decision making to decide who speaks before the other. So because we shall be having two issues to be dealt with, which is I should show interest, and secondly, it should also register the order of in how I showed interest. I do believe that we should be progressing and not retrogressing. And with reference to the House of Commons, Mr. Speaker, we are actually more advanced than the House of Commons in terms of the systems that we apply in this House, Mr. Speaker. So we should not be looking at our former colonizers and imagining that they are more advanced than we are. We are actually a bit more advanced than they are in terms of technology. So, Mr. Speaker, I do oppose.
Oh. Information to the chairman. Okay.
Honorable Chair, the information I want to give, Honorable Chair, is that sometime in the last Parliament we visited Germany, Brela, with you, with the intention of always updating them on the challenges of the system. And whenever we update them, they are able to design systems that can actually help with addressing the challenges as they emerge. So it should not be going back. We should advise Brela that this is the challenge we are having. Too few names are appearing. How can you extend the number of names? But don't take us back to standing, Honorable Speaker.
Now, sorry, the chair wants to withdraw. No, I mean, there's no point. There's no point. You know, there's still a lot of business. Remember, now that the chair wants to withdraw, why don't we?
I want to qualify and see if I'm going to allow them to take their vote.
Okay.
So, Mr. Speaker, Mr. Chair, seated where you are, you saw the Honorable Ward Chief, what he was doing when he wanted to catch your attention. He put up his hand. Now, it is worse to put up your hand and to gesture, sometimes even grimace. You know, this happens all the time. But if the members really, because we are actually trying to do this thing, by the way, I have no intention of pushing it very hard, Mr. Speaker, because many of these things that we are doing today are for the next Parliament and are for the good of members. We are bringing in things that we have seen. If the members on their own volition feel that we shouldn't progress with it, I really wouldn't have a problem with it. But I think the better way is so that I don't look like I have muzzled this thing, because this is something that came out of the committee. I think we should allow the members to vote one way or the other. To vote one way or the other, rather than withdraw. I had really thought of withdrawing, but I realize it's not my own amendment. Yeah. It's better for them to either throw it, the baby with the water, because the issue is, we have seen it, it's practical. And even the Honorable Nyasuna, the Honorable member there, the gracious lady, when she wanted to give information, which ordinarily I would have refused, but because coming from her, I cannot. It's not easy to refuse. She also stood in that place. He actually practiced this. The Honorable Duale, and I can tell you, Mr. Chair, has been, when he was the majority leader, sometimes, you know, because there is order of precedence, according to our standing orders and also the motions that we make all the time. Sometimes he has put his card and it is at the top, at the lowermost. And you know, at that point, he's a leader of majority. You really have to recognize it. But you can't see him from the gadget. This is something that we should, I think, temper it so that we have both the old and the new system. Get a little good of the old, and the House will also will look a bit, active. When you see members really wanting to contribute from the chair, you can be able to read the mood easily. But I think let's allow the members to make their decision, one way or the other.
Can I get somebody who, some contribution from, there is a technical issue that was raised by the Honorable Wanga, which I think is an important one also to consider, that actually the manufacturers of this equipment, these gadgets, can actually cure the mischief by providing at the Presidium a bigger screen, and make bigger provision. Because what the Deputy Speaker is saying is actually is true. Sometimes it can be very difficult to know who it is that, and you see, honour members, you also confuse the Presidium. Let me just also speak to this. Because some of you press the intervention buttons and you relax, and all you want is to catch, and you leave, and you block that part, making it impossible for the person on the chair to know who wanted to contribute or who wanted just to intervene. But it's one of those things that I think what has been said by Gladys Wanga also is something that should be considered by the administration of Parliament. Because you have spoken, why don't we get that member who has not spoken? Member for Gishugu.
Thank you, Chair. I do oppose that amendment. The reason that I've been given by the mover that sometimes the screen can display 4 names at once is it's better to deal with 4 names than having 20 or 30 people standing across the entire chamber. So I believe probably it can be qualified that the amendment can stand if the gadgets fail. If the system that we are using fails, that is when now we can use the system he's talking about. So that we don't lose everything from his side. He has put a very spirit and effort. But when the gadgets are operational, we use the system.
Member for Madeira has not spoken. Let me.
Thank you, Honorable Speaker. I think you have convinced me on the need of the 2 systems. And the reason is what we have continued to see in this House is where people press intervention buttons unnecessarily. But having said that, I think it is important for us to continuously upgrade our IT system and have even solutions. We can actually even come with solutions that are now real-time, so that even up to the second you can be able to know who are the top 4 in terms of interventions. We can even have a situation where even in the interventions, you can be allowed to use your pad and say exactly what is it on what matter that you really wanted to, and then the speaker can be able to pick that matter and see that you really wanted to talk on that particular issue and give you an opportunity to expound. So I support, but I think more importantly, it is important for this House, and we really want to say thank you because we've seen where we've come from. These gadgets actually have came with us in this 12th Parliament, but there is room, so to speak, for further improvements, so that we get something that is more real-time. Thank you.
Honorable Martin Owino.
Thank you, Speaker. I just want to remind members that when we are proceeding in this House, we are even being watched by the House of Commons. I had a privilege, Speaker, to meet one of my friends an MP from Croydon, and they admire how advanced and how we do our proceedings using digital system. So we should not regress. We should move on. Now, lastly, if showing hands and making noise when sitting is irritating, how about when you stand up and the lungs are open? You will not manage that, Mr. Speaker. So let's oppose this to totality and move on as we speak.
See, honourable members, those of you who are in the 11th Parliament will recall that the difficulties I would get when I would see a whole crowd of people and another one there. Now I don't know who stood before the other. There's a group of 5 or 10. Then you start now looking, the one in the bui, the one with some receding hairline, the one with some who has combed their hair this way. Now you don't even know what to. Honorable Gitonga. Yeah.
Mr. Speaker. Mr. Speaker, I watched parliamentary proceedings for the first time when I went to secondary school. That's when I saw a TV for the first time, and we would see Parliament, and it looked funny that for whatever reason they would all stand at once. One of them is picked, whether Martin Shikuku or my MP Njagi Wakiondo that time, and they would all sit down. Then after he finishes, they all stand up again. It looked very disorderly. I think what we have is good. We have been here for the last 5 years. This system came in almost when we came in. It has worked very well. Let us improve on it. Let us have a reservation that just in case it fails, we can move into those manual and the physical gestures we are talking about. But for now, let's leave it that we work with the gadgets we have so that we are moving forward, not to be seen moving backwards. Not all of us standing up at the same time, sitting down, standing up like people who've lost it. Thank you, Mr. Speaker.
Let me hear the very tall member for Tiati.
Mr. Speaker, Mr. Chairman, while the arguments that have been put forward by my colleagues are quite convincing, I still believe, Mr. Chairman, that a little bit of the old system will serve. Because speaking as a former Speaker of the County Assembly of Baringo, I know the significance of, and even the you know, when a member really wants to say something, there is that action of trying to catch the Speaker's eye. It's quite traditional. This other one of the gadget is good, but also bad in a way, because when a member is really eager to catch the Speaker's eye, there's no harm in trying to actually catch the Speaker's eye by standing up. There is no harm at all. In my view, Mr. Chairman, I think as we try to improve our systems, to try to add the number of people or honorable members who want to raise interventions, I think a little bit of the mixture of the old and the new does not do any harm.
Supposing incrementally, Honorable Kamket, we were to get these gadgets reconfigured in such a way that when a member, by accidentally places their card and presses the intervention button, it is rejected. No. First of all, it makes some sound. I think we can reconfigure it to make some sound or some light that flickers. I'm just trying to imagine something catching the eye. I'm with you on the idea of catching the Speaker's eye.
Yeah. Something
that flickers, and to an extent that there's no way the Speaker will not see that that there's something which even if your name is down there.
Yeah.
Because that I think would be, we can have it improvised.
That I could not put it any better, Mr. Chairman. But you see, Mr. Chairman, rising up on your place is a reflex action. You know, it's reflex. So it's a reflex action, and it shows the eagerness or the extreme interest of the particular member on that particular point. But I don't mind what you said, but a little bit of a mixture of both, a hybrid.
When there is failure.
Yeah.
Chair, I know everyone has a feeling about this, but we should just actually look at the principle. What mischief we're trying to cure and whether technology can actually cure the mischief. What the Honorable Kamket is talking about are bodily actions of gesturing. Let's take an example of this thing we call the iPhone, or even the iPad we are using. The man called Steve Jobs was able to translate human gestures into actionable technology. In fact, when you look at your phone, it is actually going by the dictates of normal human gestures, where the technology now assists. The problem I have with us having people shooting up out of reflex is the fact that this was a practice that was happening the last time. It was the 11th Parliament, which had 210 members of Parliament. Mr. Speaker, this is a way bigger Parliament. When we start talking about people popping up like popcorn in the House, even the Presidium itself will run into confusion, Mr. Speaker. So, Mr. Speaker, I would like to go along the line which you were talking about, where the technology itself, which we have actually bought, is a technology that can be improved. We work on the problem that is the issue of catching the Speaker's eye and establishing the order in which the Speaker is going to identify the people who have shot up. Mr. Speaker, I do believe that technology can have a solution for the mischief that we're trying to cure. Thank you very much, Mr. Chairman.
Very well. I think everybody has spoken to it. Can I put the question? I put the question, which is that standing order number 83 be amended as proposed on the order paper. Will as many as that opinion say aye? Aye. As many as the contrary opinion say nay? No. The nays have it. So it remains. No? So I put the question, which is that standing order 83 be part of the standing orders. As many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing order 84.
I propose that standing order 84 be part of the standing orders. Mover.
Mr. Speaker, this is the difficulty now with being, bringing a committee report. Sometimes you don't know whether to withdraw, because when you withdraw again, you have not had a meeting. I tried to meet with a few of my colleagues who are in that committee to try and withdraw the previous one, but we couldn't make a decision on our own. We said let the members do. So let me move that standing order number 84 be amended as proposed in the order paper. This is purely to delete and reintroduce the provisions in standing order 44 that deals with statements for the logical flow of the standing orders.
I propose the question, which is that standing order 84 be amended as proposed in the order paper. I don't know, members, I hope if you can reflect back what we just passed as an amendment to standing order 44, it is now to remove personal statements from where they were. They appeared a bit misplaced. They were in a bush where they never belonged. So essentially this is actually to repeal, isn't it? It's actually to delete standing over 84 as it is. So I put the question, which is that standing order number 84 be deleted. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing orders 85 and 86.
I propose that standing orders 85 and 86 be part of the standing orders. There are no amendments. I therefore put the question, which is that standing orders 85 and 86 be part of the standing orders. Will as many as that opinion say aye? Many of the contrary opinion say nay? The ayes have it.
Standing order 87.
Propose that standing order 87 be part of the standing orders. Mover.
Thank you, Chair. I beg to move that Standing Order number 87 be amended as proposed in the order paper. This is a very critical one, Mr. Chair. It's about the issue of using and relying on media as authorities, as authority in the House. This is to preclude a member from relying on extracts from media as authorities when addressing the House. Mr. Speaker, the only good bit about this is that the Speaker is also given the power to allow in exceptional circumstances. Because sometimes members would bring even some very unreliable extracts from media that are probably even not recognized, and therefore it creates issues in the House. Thank you.
I propose a question which is that Standing Order 87 be amended as proposed on the order paper. Honorable Duale.
Mr. Speaker, as I support, I think we should be very careful because we should not look like we are curtailing the freedom of the media. And our standing orders, Mr. Speaker, are drawn mainly from the Constitution and statutes that this House passes. And I'm sure that the only thing that makes me comfortable is except as the Speaker may otherwise allow, which is very, very good, a safeguard. But I think it should not look like we are saying, because sometimes what the media reports is factual. It's factual. You know, we are talking of the mainstream media, not social media, not gutter press. So I think, the Speaker has the leeway, the Speaker has the safeguard. I support.
The only thing is that the media is not being gagged. The media is at liberty to report anything they choose. You know, they don't mind. They have no, sometimes they have absolutely no responsibility for many of the things that they do. But I think the idea is to try and minimize over-reliance on, you need, as Parliament, you need to have documents that that are authoritative. The media is never authoritative on anything. But in some jurisdictions, you recall, and even within Kenya, some years back, many years back, there was one media house which was fairly authoritative. It used to be called the Weekly Review. But now these others, these days, they pick their stuff from the gutter, they put it in the mainstream. Then, so I think it's good that there's some leeway, that some leverage that is left, discretion left on the Speaker. If it's something that is a matter of public authority that is being reported on, the Speaker obviously will not be so impervious as not to have also taken notice of it. Honorable Makali.
Yeah, Honorable Speaker, I think I like the way you are putting it now, because Honorable Speaker, in some of the articles in the media, they are very well researched by very renowned scholars. And I wish I would have said that we allow some room for verification so that if I'm quoting the media, then I must have checked the accuracy of the information before I quote it. Because actually there are some good articles you read and you find this a well-researched paper and there's an authority you can quote. But the fact that you are saying the Speaker might allow, I think as a member of Parliament, I will only be allowed to provide the proof that this is an accurate piece of information coming from the media. Thank you. I support.
Very well. I put the question, which is that Standing Order 87 has to be amended as proposed in the order paper, with as many as that opinion say aye. As many as contrary opinion say nay. The ayes have it. Put the global question, which is that Standing Order 87 as amended be part of the standing orders. With as many as that opinion say aye. As many as contrary opinion say nay. The ayes have it.
Standing Orders 88 and 89.
Proposed that Standing Orders 88 and 89 be part of the standing orders. There are no amendments proposed, so therefore put the question, just that Standing Orders 88 and 89 be part of the standing orders. Will as many as of that opinion say aye? As many of the contrary opinion say nay? The ayes have it.
Standing Order 90.
The proposed that Standing Order number 90 be part of the standing orders. Mover.
I beg to move that Standing Order 90 be amended as per the order paper. This is to outline the manner of recording of declarations of interests by members and to empower presiding officers to determine the nature, effect, and extent of interest, of how interest may prejudice the proceedings of committees. Sometimes you might have an interest. You might speak about something of Nairobi University. And I really do not need to declare an interest, for example, that I was in that university, because those are issues that are not. So we'll be able to determine at that point in time the extent to which it affects the proceedings of committees. There are some interests, unless strictly pecuniary, really will not affect the proceedings of committees.
I propose a question, which is that Standing Order number 90 be amended as proposed in the order paper. Honorable Duale.
Speaker, I had my own amendments, but I forgot this. Mr. Speaker, I think particularly in the 12th Parliament and part of the 11th Parliament, the problem is people don't declare their interests. People even appear, they sit in a committee where a company where they're even shareholders or doing business with, or they have worked for. For example, Speaker, this time order talks about if I have worked with Safaricom before, or Airtel, or any other company, before coming to the House, and I become a member of the ICT committee member, when that company is appearing before, just because of the history, you declare your interest. Even when we have got vetting, if in one way that personality is from your county or your constituency, Speaker, you need to declare your interest. And I think that is part of transparency and good governance. So I think we've never been doing it, but I think the Honorable Deputy Speaker, as the chair who's moving, has done it well, and I'm sure in future we will make it now mandatory. And in the event the chair of that committee realizes that member did not declare his interest and participated in the deliberation, then the Speaker, there must be a recourse to that effect. I think the kind of interest is a matter that's even within the judiciary and everywhere in government. I support.
I put the question. This is that Standing Order number 90 be amended as per the order paper. Will as many as a lot of opinion say aye? Many of contrary opinion say nay. The ayes have it. Put the global question that Standing Order number 90 as amended be part of the standing orders. Will as many as a lot of opinion say aye? As many of contrary opinion say nay. The ayes have it.
Standing Orders 91, 92, 93, and 94.
I propose that Standing Orders 91, 2, 3, and 4 be part of the standing orders. There are no amendments proposed. Therefore, put the question, which is that Standing Orders 91, 92, 93, and 94 be part of the standing orders. Will as many as lot of opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 95.
Propose that Standing Order number 95 be part of the standing orders.
I thank you, Chair. I beg to move that Standing Order 95 be amended as per the order paper. This is that particular bit of cutting debate. What we are trying to do is to allow members desirous of debating a bill to amend the Constitution an opportunity to do so without a threat of majority of the members present resolving to close debate at any point they so wish. To be very clear, Honourable Speaker, I remember every time that we have members contributing on ordinary bills, a member can rise in his place and ask that the caller be moved to reply. Now, on a constitutional issue, it is an extremely serious issue. So members must be allowed and must be seen by the public also to have been allowed to move anything that they desire to do as amendment to the Constitution without threat of curtailing debate. We give it sufficient time.
I propose a question, which is that Standing Order number 95 be amended as per the order paper. Honorable Gishimo.
Thank you, Chair. That is extremely important. And I believe in future we should also look at the bills, because where especially members have contrary opinions. Because we've seen debates curtailed by some people just by standing or invoking Standing Order 95. And members usually have different opinions in their contributions. I believe with what has now started, probably we can improve in future and move even to the matters bills. Thank you, Chair. I support.
Very well. I propose the question. Oh, sorry, Honorable Owino.
Speaker, I'm just wondering because even when when somebody proposes that the debate stops, still is subjected to vote. So I don't know how this will improve that, because sometimes we have this protraction because other people just want to do it for the sake of it. And that also happens. So I don't know. I thought we were good with that leverage of subjecting what had been proposed to pass through. I think that was giving a good breathing space. So I don't know. I don't want to oppose. I don't want to say, but I just
ordinary bills. It spoke about ordinary bills, but this one is relating to bills proposing to amend the Constitution. That's what I understood it to be. Anyhow, I put the question, which is that Standing Order number 95 be amended as proposed in the order paper. Will as many as that opinion say aye? As many as that opinion say nay? The ayes have it. I put the global question, which is that Standing Order number 95 as amended be part of the standing orders. Will as many as that opinion say aye? As many of the contrary opinion say no? The ayes have it.
Standing Order 95A.
I propose that Standing Order number 95A be part of the standing orders. There being no amendment proposed, I put the question, which is that Standing Order number 95A be part of the standing orders. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing Order 96.
I propose that Standing Order number 96 be part of the standing orders. Mover.
I beg to move that Standing Order 96 be amended as per the order paper. Mr. Speaker, I do not want anybody to have confusion on this. The previous one we did is on closing of debate. This one we are dealing with adjournment of debate. So the justification here is that we allow members desirous of debating a bill to amend the Constitution adequate opportunity to do so without threat of majority members present, resolving to adjourn debate at any point. Adjournment of debate. The other one was on closure of debate.
I propose a question, which is that Standing Order number 96 be amended as per the order paper. Put the question, which is that Standing Order number 96 be amended as per the order paper. Will as many as that opinion say aye? Aye. The contrary opinion say nay? The ayes have it. Put the global question, which is that Standing Order 96 as amended be part of the standing orders. Will as many as that opinion say aye? As many of contrary opinion say nay? The ayes have it.
Standing Order 97.
I propose that Standing Order 97 be part of the standing orders. Mover.
I beg to move that Standing Order 97 be amended as per the order paper. The previous one was adjournment on debate. The much earlier one was close of debate. This one is to allow members desirous of debating a bill to amend the Constitution adequate opportunity to do so within any time limitation that the House may agree to impose.
I propose that Standing Order 97 be amended as per the order paper. I put the question, which is that Standing Order number 97 be amended as proposed on the order paper. Will as many as that opinion say aye? As many of the contrary opinion say nay? The ayes have it. Put the global question, which is that Standing Order number 97 as amended be part of the standing orders. Will as many as that opinion say aye? As many of the contrary opinion say nay? The ayes have it.
Standing Orders 98, 99, 100, 101, 102, 103, 104, 105, 106, 107, 107A, 107A, 109, 110, 110A, 110B, 111, 112, and 113.
I propose a question, which is that Standing Orders 98 through to Standing Order 113 be part of the standing orders. There being no amendments proposed, I put the question, which is that standing orders 98 through to 113, be part of the standing orders. Will as many as that opinion say aye? Aye. As many of contrary opinion say nay? The ayes have it.
Standing order 114.
I propose that standing order 114 be part of the standing orders. Mover.
I beg to move that standing order 114 be amended as per the order paper. This will allow co-sponsorship of legislative proposals and bills. It will also increase the period of pre-publication scrutiny from 21 to 30 days, and also will help to actualize Article 256(2) of the Constitution on the introduction of bills to amend the Constitution and collection of varied views from members and constitutional officers.
I propose that standing order 114 be amended as per the order paper. Yes, Honorable Duale.
Mr. Speaker, the chair is not fair. I want him to explain properly. There's a lot in this. He is deleting the whole of section. Are you at 1114A?
No.
Okay. Yeah. I'm sorry.
Very well.
That's why he has.
I put the question, which is that standing order 114 be amended as per the order paper. Will as many as of that opinion say aye? As many of the contrary opinion say nay? The ayes have it. I put the global question, which is that standing order number 114 as amended be part of the standing orders. Will as many as of that opinion say aye? As many of the contrary opinion say nay? The ayes have it.
Standing order 114A.
I propose that standing order 114A be part of the standing orders. Mover.
I beg to move that standing order 114A be amended as proposed in the order paper, and the justification is to allow the Speaker to exempt the following legislative proposals from pre-publication scrutiny. A proposal from the Constitutional Commission or independent officers, provided that they relate to the mandate of the body and are accompanied by policy underpinnings of the legislative proposals and evidence of stakeholders consultation conducted. 2, or B, proposal that seek implementation to implement a resolution of the House or recommendation of enactment of laws just a minute, proposal that seeks implementation of a resolution of the House or a recommendation for the enactment of laws as a response to a petition, proposal identical to those passed by the House but lapsed in the preceding Parliament, and C, proposals of returning members that were read, proposal of returning members, those members who made proposals in the previous term that were read a second time but lapsed in the preceding Parliament. Mr. Speaker, Mr. Chair, particularly that last one. Once Parliament is, we get to another Parliament, there are members who will have been re-elected. It would not be of any use. It will actually be expensive and unnecessarily difficult for members to restart a bill which had gone through all the processes, including all the pre-publication processes, to be asked to start afresh. It is costly and unnecessary because some of the things will have been dealt with in the previous term, particularly if it is the same member who is actually proceeding with the coming bill.
I propose that standing order 114A be amended as per the order paper. Honorable Duale.
Mr. Speaker, I really want to thank the chair. This is a very good amendment because, Mr. Speaker, it was only the executive which was enjoying a lot of privilege from the Speaker in giving them that leeway. But now you can see even a member, an honorary member or a committee, or even when your proposal dies in the Senate, the time frame has really changed. But more important, Mr. Speaker, Boy's amendment is that a member cannot be used to amend the Constitution by himself, to bring a proposal to amend the Constitution by himself. He must get the support of the signatures of either 50 members or use his majority party leadership or minority party strength in the House. Speaker, because we had all sorts of bills here to amend the Constitution. Because, for example, Mr. Speaker, if you have issues with the DPP or the Inspector General of Police, or with another independent commission, or devolution, you just come and propose to amend certain sections. So this threshold of 50 members, or you go back to your party, either minority or majority, will give the people of Kenya that this is a serious thought amendment to the Constitution. I support.
Honorable Wino.
Mr. Speaker, I want to thank the chair for this. It's very tedious to come up with a bill and move it through all these stages. Mr. Speaker, I know most of us here are going to be victims because mine, community health workers, have just passed through, and I know is going to die in the Senate. And this is a bill that went through all the participatory of stakeholders. Now to go back again to the the stakeholders and say the same thing, they might think you're joking. So if it is the same person having the same bill, this makes a lot of sense. I support.
I therefore put the question, which is that standing order 114A be amended as per the order paper. Will as many as of that opinion say aye? As many as the contrary opinion say nay. The ayes have it. And therefore put the global question, which is that standing order 114A as amended be part of the standing orders. Will as many as of that opinion say aye? As many as of the contrary opinion say nay. The ayes have it.
Standing orders 115, 116, 117, 118, and 119.
I propose that standing orders 115, 116, 117, 118, and 119 be part of the standing orders. There are no proposed amendments. I therefore put the question, which is that standing orders 115, 116, 117, 118, and 119 be part of the standing orders. Will as many as of that opinion say aye? As many as of the contrary opinion say nay. The ayes have it.
Standing order 120.
I propose that standing order 120 be part of the standing orders. Mover.
I beg to move that standing order 120 be amended as per the order paper. The justification is to combine the current 122 and standing order 120 for logical flow of the provisions and require publication of a bill with the names of co-sponsors in the assembly, if any.
Well, I propose that standing order 120 be amended as proposed on the order paper. I put the question, which is that standing order 120 be amended as per the order paper. Will as many as of that opinion say aye? Aye. As many as the contrary opinion say nay. I put the global question, which is that standing order 120 as amended be part of the standing orders. Will as many as of that opinion say aye? Aye. As many as the contrary opinion say nay. The ayes have it.
Standing order 121.
I propose that standing order 121 be part of the standing orders. Mover.
I have shifted to this one. I've shifted here, Mr. Chair, because there is a space for me to stretch my leg. Getting a little taller. So I move that standing order number 121 be amended as per the by the order paper. This is basic. The justification is to align the provisions with Article 110 of the Constitution. Fairly straightforward.
On quorum, Honorable Deputy Speaker, on the issue of quorum, 121?
120.
No. Or the issue to deal with counties.
This is different, yes.
Well, I propose the question, which is that standing order 121 be amended as proposed on the order paper. Honorable Duale.
Chair, I think this matter, we are just restating it because the Constitution under 110 is very clear, only that the Senate was misbehaving, as usually. And the Attorney General of the Republic of Kenya, I think as the Chief Legal Advisor, should, when he's sending bills through the Cabinet, should also indicate, and he indicates, about which bill concerns counties and which bills does not concern counties. But I can see the chair is deleting Section 3, which reads, pursuant to Article 110(3) of the Constitution, the Speaker and the Speaker of the Senate may agree on an appropriate framework for jointly resolving. Speaker, I totally support the chairman. There is nothing to agree. There is no need for framework. The Constitution is alive and is speaking. So I think even in the 11th Parliament, when we put 121.3, I think it was an oversight. So it's good the chairman has deleted it. There's nothing to resolve. There's no framework. The framework and the beams and the columns have been provided for in the Constitution.
I put the question, which is Standing Order 121, be amended as per the order paper. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it. Put the global question, which is Standing Order 121, as amended, be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Order 122.
Propose that Standing Order 122 be part of the standing orders. Mover.
I beg to move that Standing Order 122 be amended as proposed in the order paper. This, remember, we had merged it in at 120, so it's basically to combine the text of Standing Order with that of Standing Order 120 for the logical flow of the standing orders.
I propose that Standing Order 122 be amended as per the order paper. I put the question. This is a Standing Order 122 be amended as per the order paper. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the global question. Oh, it's like a deletion.
Yes, we are deleting it.
Yeah.
Sorry, we are deleting it because already it's captured at 120.
Oh, yeah.
Yes.
So it's be amended as per the order paper. Yeah, which is deletion. Next.
Standing Orders 123, 124, 125, and 126.
I propose a question, which is that Standing Orders 122, 123, 124, 125, and 126 be part of the standing orders. There being no amendments, I put the question, which is that Standing Orders 123, 124, 125, and 126 be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Order 127.
Propose that Standing Order 127 be part of the standing orders. Mover.
I beg to move that Standing Order 127 be amended as per the order paper. The justification is to increase the submission of a report on a bill to the House to 6 days for purposes of enhancing public participation.
Very well. I propose a question, which is that Standing Order 127 be amended as per the order paper. I put the question, which is that Standing Order 127 be amended as per the order paper. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it. Put the global question, which is a Standing Order 127, as amended, be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Orders 128, 129, 130, 131, 132, 133, 134, 135, 136, 136A, 137, 138, and 139.
I propose the question, which is that Standing Orders 128 through to 139 be part of the standing orders. There being no amendments thereto, I put the question, which is that Standing Orders 128 through to 139 be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Order 140.
Propose that Standing Order 140 be part of the standing orders. Mover.
I beg to move that Standing Order 140 be amended as proposed in the order paper. The justification is to require that a member who seeks to seek leave of the Speaker before withdrawing a bill introduced to implement a resolution of the House or recommendation to enact laws in response to a petition.
I propose a question, which is that Standing Order 140 be amended as per the order paper. I put the question. Sorry, Honorable Duale.
I really want to ask the Honorable Cheboy if this amendment also affects government bills. Because government bills, I think the leader of majority, in consultation with the speaker, can withdraw. So is it members or even leader of majority?
It doesn't.
Because there's a likelihood that we are forming the next government, so we have to protect our turf.
No, it doesn't. It doesn't, and it's very clear. We have talked about bills introduced to implement resolutions of the House or recommendations to enact laws in response to a petition.
Yeah, in answer to Article 119, where anybody can petition Parliament to even enact or repeal law. So I put the question, which is that Standing Order 140 be amended as per the order paper. Will as many as those opinions say aye? As many as contrary opinions say nay? The ayes have it. I put the global question, which is that Standing Order 140 be part of the standing orders. Will as many as those opinions say aye? As many as contrary opinions say nay? The ayes have it.
Standing Order 141.
The proposal that Standing Order 141 be part of the standing orders. There's no amendment there too. Therefore, I put the question, which is that Standing Order 141 be part of the standing orders. Will as many as those opinions say aye? As many as contrary opinions say nay? The ayes have it.
Standing Order 142.
Proposal that Standing Order 142 be part of the standing orders.
Thank you. Thank you, Chair. I beg to move that Standing Order 142 be amended as proposed in the order paper. Now, this is a very good one, Mr. Speaker. I wish I could convince members easily on it. Is to allow co-sponsorship of an assembly bill, our bill at the National Assembly, in the Senate. So many times some of our bills that go to our sister house fall because there is lack of interest the other side. So the easier bit now, the easier way to handle this matter is for a member, if you are able to get a Senate member the other side so that you can co-sponsor the bill. Once we are through with the bill here, it goes there, it goes specifically to a member who will be able to process it fast.
I propose that Standing Order 142 be amended as per the order paper. Honorable Dwele.
That's a very risky business. Because you can pass your bill here, and then the person you have given there can be bought or influenced by certain people that bill touches. So I think the Speaker, let us not go that route. I mean, if you are a member of Parliament, you have a bill here, you have all the right, the Senate, to discuss it through a committee because your message as the Speaker of the National Assembly is important. But now if we have to go like nomads to look for somebody, that person will not be there when maybe the day to move. He can be told by, if it was touching on a certain industry, cartels will buy that member. He is not under obligation. So, Mr. Speaker, I really want to ask my colleagues and ask the chair, don't take us to, we are respectable members. We represent constituency. We represent interests. And this is a bill that you have researched on. You have put your energy and time. And that person, the Speaker, even to look for a seconder here. When you have a bill here, to look for a seconder, you have to convince him, you have to give him part of your notes. And he's a colleague in this House. What about a member of the Senate? And you know the rivalry we have with the Senate. They can even conspire to tell him, my friend, withdraw that Senate. So I really want to ask the member to withdraw.
Let me see, Honorable Chair, if I can, as other members contribute. Let me be very clear. Chair, let me request that I just clarify something.
Okay.
Yeah. Chair, this is, in fact, I'm extremely surprised that members would have an issue with it because, first of all, it's not a must. I mean, you have a choice. But remember, when we have a government bill in the National Assembly, it falls into the hands of the leadership of government in the Senate. That one is dealt with. Now, here is a situation whereby a member has a very, very critical issue. And he decides, like, for example, look at some of the bills that have been sponsored by Millie Odhiambo. All you need to do is to look for somebody the other side to help you enhance and make it fast. Really, it has no harm. I am actually surprised that is a matter because if you really think it is a matter you don't need to look for somebody there, it will go to the Senate. Whether it falls or it doesn't in Senate is really not up to your business. But if you want to partner with a senator the other side, who shares aspirations like yourself here, I think
this is merely to expand possibilities. It is not limiting. It is not limiting a member. Let's hear the Honorable Kilo.
It says a member in charge of the bill shall, not may, shall within 7 days notify the Speaker in writing of the name of any member or members of the Senate that the member has nominated to co-sponsor the bill in the Senate. So it's a mandatory. Yeah.
But that is if you choose that you need co-sponsorship. Otherwise, the bill will ordinarily go to the committee, the relevant committee in the Senate. But sometimes you could have somebody in the Senate with whom you have quite some, some rapport, and you think that if he or she were to take up your matter, it would move faster than if it just goes to a general committee. But nevertheless, honourable members, let's hear from Honourable Charles Kilonzo.
Mr. Speaker, my concern when he says a bill can be co-sponsored, for example, is a bill originating from this House, and it comes here as a bill co-sponsored with a senator from the other House. I'm concerned with the legalities, because the people who can bring bills in this House are only members of this House. So will it be legally possible to say I'm co-sponsoring this bill in this House with somebody who is not a member of this House? That's where I'm really sort of lost.
I think the only thing, for me, I think the thing which we needed to find out is whether, because it is a matter that we have discussed in the past, and it's almost something that we had come to an agreement. I just wanted to know whether Senate are going to amend their standing orders to be in accord with ours. That was the only difficulty. Actually, the people who have even greater problems, are the senators. Because, most of the bills, 97 or 98%, 98.5% of most of the bills in the Senate are actually private members' bills. So it is something we have had occasionally. Honorable Duale, we have discussed this thing with the leadership of the Senate, and we have always explored this possibility. It happens in some other jurisdictions. It's a good way to ensure that if you have somebody, not just a committee, if you have somebody whom you can always keep calling and finding out, please, how far has it gone? Just like the way you would follow it yourself. I see many of you coming to my office, where is my bill? Well, so that when it is there, it is not just left to the committee. You have somebody who is pushing it for you, because he or she is co-owner, is co-owner of the bill. But the only thing I didn't know is whether this arrangement has been, because we told the senators we can do it ourselves here, we can agree, but because they have a problem. Let me not get there. We consider more than 95% of government bills here. But even the ones that the concerned counties, when they go there, then they start telling you we are not getting delegates. I don't know who is not available. Now, even those ones have problems. But I just don't know. Maybe from the technical people, or Deputy Speaker, this thing we had agreed that they should be doing something corresponding, isn't it?
Yes, Chair. That is the position, Chair. But see, we can as well put this in our standing orders. Whether they do it or not is really not quite a matter of our problem, because we will have done our bit. If we are able to fix it through there, we'll be able to use it. You can imagine if they agreed now and we do not have something that is supporting from our own standing orders. So, and by the way, I think the main confusion is this co-sponsorship, because it's really that the member who is in the National Assembly has sponsored his bill, but looking for somebody in the senator who will be able to own that one when it is in the Senate. But when it comes out, it will not be that there is a co-sponsorship, no. And that is what it will cure the Honorable Kilonzo's fear. There will be nothing illegal at all, because the bill will belong to the originator.
Honorable Wino. Okay.
The Speaker, I really support this. If I knew with my bill, which I know is going to die in the Senate, I may not use co-sponsorship, but use in another way, co-investment of an interest.
Absolutely.
So that you pursue together. I would have pulled it through, because 2 months now of interest. I've been chasing even the person I believe is a health chair and a friend of mine to push this. And they're not taking it because of personal reasons, I understand. So I think this is a good thing. If we invest that, I think we can move our bills quickly. Because when you struggle with a bill, you would like to see the outcome. And if it dies, it's really frustrating. So I support.
But fortunately, you've already now saved through the other amendment, the one we have passed already, so that it will not die. It will just go into some slumber. So the Honorable Owino, the people of Diwa must bring you back so that you come and resuscitate that bill. Yeah? Honorable Kishimo.
Thank you, Speaker. I agree with the last explanation that has been given by the Speaker, that the bill that comes to Parliament ought to be sponsored by the member of the National Assembly, for example, so that it will not appear like it is co-sponsored, because though the Constitution recognizes the Parliament to consist of 2 houses, but these 2 houses are different institutions. So once the bill is dispensed with at the National Assembly, then someone can write that authority of co-sponsorship by a person from the Senate. I think that that's now very clear to avoid a legal issue when it comes to who has, because 2 members of Parliament, then the Senate and the National Assembly cannot at the same time participate in a matter. Thank you.
Very well. I put the question therefore, which is that Standing Order 142 be amended as per the order paper. Will as many as of that opinion say aye? As many of the contrary opinion say nay? The ayes have it. Put the global question, which is that Standing Order 142 as amended be part of the standing orders. Will as many as of that opinion say aye? So many of the contrary opinion say nay? The ayes have it.
Standing Order 143.
Propose that Standing Order 143 be part of the standing orders.
I beg to move that Standing Order 143 be amended as proposed in the order paper. Now, the previous one was a bill getting out of this House to the Senate. This is now what we expect the senators to do. We are actually also anticipating that they will also want the same thing. So this is consideration of bills originating in the Senate, and therefore allowing co-sponsorship or a member here showing interest that they want to handle a matter that comes from a particular senator from the other house. So it's the other way around now.
I propose a question, which is that Standing Order 143 be amended as per the order paper. Yeah? Honorable Duale.
Mr. Speaker, I think you need to guide us here because you have given good guidance since 2013. I have no problem with this amendment, but the Constitution talks about origination of bills, specifically which bills to originate from this House, which bills to can originate from the Senate, which bills are money bill and where they should originate from, even the impeachment of the President and the Deputy President, where they're supposed to originate. Now my question is, a senator must act legislatively within the confines of the Senate. How does it work for us here if I have a bill and then the senator for Garissa co-signs with me and the bill is supposed to originate from here? So I think, how do we deal with it? Are we not infringing on the Constitution? And I think that is what Honorable Charles Kilonzo raised. Can we bring a foreigner, a senator, to even have his name appear on a bill as a co-sponsor in a house where he has no legislative jurisdiction and powers? I think that's number one, Mr. Speaker. You need to guide us. Secondly, Speaker, what we are doing here needs also the concurrence and amendment to the Senate standing orders. If the Senate will not do in their standing orders what we are doing, then this is a waste of time. Oh, there's another one here, sorry. So, Mr. Speaker, I think you need to guide us. Because I stood in for an election to be a senator. The moment I have been sworn in, I have absolutely no constitutional legislative powers in this house. The same for a member of parliament. Secondly, so how does a bill that ought to originate only from this house has a senator as a co-sponsor? Then the constitutionality of that, but because the standing order is inferior to the Constitution. If the standing order is made from the Constitution. So, Mr. Speaker, I think now as the Speaker, today I'm happy. I think this should be, the Speaker usually sits the longest time in the amendments to the standing orders. That's the time when the substantive Speaker, they sit as the chair of the committee the longest. But maybe you can guide us. As you sit there, you can give us whether what is the constitutional parameters.
I think perhaps the only area where we may have to, which I think is a matter for the speakers would have guided during the entire process of pre-publication scrutiny, is where anything goes against the provisions of Article 109, Clause 5. 109 Clause 5, where it says that, Clause 9, starts by saying that, any bill may originate from the National Assembly, from either house, but money bills may only originate in the National Assembly. I suspect that's where the Honorable Duale may be having some difficulties. Yeah.
Chair, these standing orders cannot be used to amend any legislation or the Constitution. Standing orders are meant for the comfort and happiness of the members of this House, to make work easier for them. Now, there is absolutely nothing that can be used from this standing order that can be used to change. Look, any bill that is supposed to originate from the National Assembly, we cannot, by standing orders, take it to the Senate. But what we are saying, look at the members especially. Now the Honorable Member Ward Chief has indicated a specific case like his. If we had some form of arrangement where we can be able to push, it would make it easier. We are basically trying to make things easy for members of parliament. Don't be the ones who make it difficult for yourself. We cannot at all. If there are, obviously there are bills that can originate from the Senate, is a fact. And quite a number of them are here. Quite a number of them fall because, we have quite a lot of things to do ourselves. So what we are saying is that sometimes we can also be useful even for the other house, just like we expect that they can also be useful to us if we get into a sort of arrangement where things can be made faster. If they do not put anything in the standing orders on their end, Mr. Chairman, I don't think we will have lost anything. That will be something, and there are some parts of the standing orders that are existing, but we are not using them. So it will be the same thing. If they do not do it and they do not feel it is important, really, we will have given it a try to try and help the legislative process.
In fact, I think the proposed amendment is actually just adding us this paragraph B, only on information, isn't it? It's not actually touching the entire standing order as it was previously. Yeah. Yes, Honorable Wino.
Speaker, that's my understanding.
Yes.
In the previous amendment, we opened the door for ourselves.
Yes.
But in this one, now we are opening the door for them. Should they choose for bills originating from their house, then they can co-sponsor.
It's just to inform.
We are all parliamentarians, Mr. Speaker. There is no foreigner here.
Yeah. But just to the extent that it's information, it's not touching on where the issue of origination. Jurisdiction is not affected. This does not touch jurisdiction. Honorable Gishimo.
Chair, the issue of originality is not affected.
Yes,
because
it's not affected.
The bill comes with an authority for someone to pick it from where it goes next. So if it comes here, at least someone is there here to pick it up. But the originality still remains.
Yes. It doesn't affect the origination. So, honourable members, I put the question, which is that standing order 143 be amended as proposed by the order paper. As many as that opinion say aye. As many as that opinion say nay. The ayes have it. Put the global question, which is that standing order 143 as amended to be part of the standing orders. With as many as that opinion say aye. As many as the contrary opinion say nay. The ayes have it.
Standing order 144.
Propose that standing order 144 be part of the standing orders. Mover.
I thank you. I beg to move that standing order 144 be amended as proposed in the standing orders. The justification is to allow transmission to the Senate of a schedule containing the specific amendments made by the House to the Senate bill for ease of tracking and consideration of the amendments. So basically, the House, it's an easier one.
It's a cleaning up, yeah. I propose a question, which is that standing order 144 be amended as proposed as per the order paper. Put the question, which is that standing order 144 be amended as per the order paper. Will as many as other question say aye? Aye. As many as the says nay? The ayes have it. Put the global question, which is that standing order 144 as amended be part of the standing orders. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing orders 145, 146, 147, and 148.
I propose that standing order 145, 146, 147, and 148 be part of the standing orders. There being no amendments, I put the question, which is that standing orders 145, 146, 147, and 148 be part of the standing orders. Will as many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing order 149.
I propose that standing order 149 be part of the standing orders. Mover.
I beg to move that standing order 149 be amended as proposed. This is basically a housekeeping one to align the provisions on mediation with Article 113 of the Constitution. I'm just saying it's to align the provisions on mediation with Article 113 of the Constitution.
I propose the question, which is that standing order 149 be amended as per the order paper. I put the question, is that standing order 149 be amended as per the order paper. Will as many as that opinion say aye? Aye. Many of the opinion say nay? The ayes have it. The member from Kilome, is it Kilome? This member from Kilome, he came in and found a completely difficult situation. He hasn't seen this before. I thought you could have sat a bit so that you can learn this. If you are coming back to the 13th Parliament, I think you need this one. Come and know what is being prepared for the 13th Parliament. Unless the villagers have told you they have terminated your contract. You are coming back, aren't you? Oh, Honorable Zengo. Oh, Mwingi North. Yes. Now you are coming back, aren't you? Yes. Now come and hear what you will find when you come back. Things will have changed. So I put the global question, which is that standing order 149, as amended, to be part of the standing orders. Will as many as have opinion say aye? As many as opinion say nay? The ayes have it.
Standing orders 150, 151, 152, 153, 154, 155, 156, 157, 158, 159, 160, 161, 162, 163, and 164, and 165.
I propose the question, which is that standing orders 150 through to 165 be part of the standing orders. There being no proposed amendments, I put the question, which is that standing orders 150 through to 165 be part of the standing orders. Will as many as that opinion say aye? Aye. Will the contrary opinion say nay? The ayes have it.
Part 21.
I propose that part 21 be part of the standing orders.
I thank you. I propose that part 21 be amended as proposed in the in the order paper, which is basically the standing order to be amended by deleting the heading to part 21 and substituting thereof with the following heading: ratification of treaties. This is to insert a new part on the manner of ratification of treaties by the House.
I propose a question, which is that part 21 be amended as per the order paper. I put the question, which is that part 21 be amended as per the order paper. Will as many as other opinions say aye? Will the contrary opinion say nay? The ayes have it. That has the effect of deleting all those, isn't it? Not yet. Proceed.
Of the heading.
Now, standing orders 166, 167, 168, 169, and 170.
About 171. I propose that standing orders 166, 167, 168, 169, and 170 be deleted as proposed on the order paper. I put the question, which is that standing orders 166, 167, 168, 169, and 170 be deleted. Will as many as that opinion say aye?
Aye.
As many as contrary opinion say nay? The ayes have it.
Standing order 171.
I propose that standing order 171 be part of the standing orders. Over.
I beg to move that standing order 171 be amended as per the order paper. This is basically, Honourable Chair, to increase the number of members of the House Business Committee from 9 to 14 to make it efficient and also to accommodate varying interests. Remember, there will be quite a number of their parties, their other interests. So the expansion will make it efficient, and in any case, it was sometimes we have problems with quorum and availability of members, so when we increase, it makes it easier for meetings to be transacted.
What's the question, which is that standing order 171 be amended as per the order paper? I put the question, which is that standing order 171 be amended as per the order paper. Will as many as that opinion say aye? Aye. As many as the contrary opinion say nay? The ayes have it. Put the global question, which is that standing order 171 as amended be part of the standing orders. As many as that opinion say aye? As many as the contrary opinion say nay? The ayes have it.
Standing order 172.
Propose that standing order 172 be part of the standing orders. Over.
I beg to move that standing order 172 be amended as proposed. Basically, this is to require the Committee on Selection to take into account interests of parties other than parliamentary parties. There will be smaller parties and so forth, and all our members elected, and therefore it would be good to accommodate all their views. I thank you.
I propose a question, which is that standing order 172 be amended as proposed on the order paper. I put the question that standing order 172 be amended as proposed as per the order paper. With as many as other opinions say aye, as many as the contrary opinion say nay. The ayes have it. Put the global question, which is that standing order 172 as amended be part of the standing orders. Will as many as other opinions say aye? As many as the contrary opinion say nay? The ayes have it.
Standing Order 173.
Proposed that Standing Order 173 be part of the standing orders. Mover.
Thank you, Chair. I beg to move that Standing Order 173 be amended as proposed in the order paper. Same as the previous one, is to require the Committee on Selection to consult parties other than parliamentary parties, including independents, when constituting committees.
I propose the question is that Standing Order 173 be amended as proposed in the order paper. I put the question is that Standing Order 173 be amended as per the order paper. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it. I put the global question, which is that Standing Order 173 as amended be part of the standing orders. Will as many as without opinion say aye?
Aye.
As many as contrary opinion say nay? The ayes have it.
Standing Order 174.
Propose that Standing Order 174 be part of the standing orders. Mover.
I beg to move that Standing Order 174 be amended as proposed in the order paper. Just as the previous one, it is to require the Committee on Selection and the Speaker to ensure interests of parties other than parliamentary parties and independents are taken into account in the allocation of members into committees, so that we don't have problems like we had before with some very, very small parties, maybe one-member parties and so forth, because they are still representative.
Good proposal. I propose a question, which is that Standing Order 174 be amended as proposed in the order paper. I put the question, is that Standing Order 174 be amended as per the order paper? Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it. And I put the global question, which is that Standing Order 174 be, as amended, be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Order 175.
Propose that Standing Order 175 be part of the standing orders. No amendment proposed, so therefore put the question just as that Standing Order 175 be part of the standing orders. Will as many as without opinion say aye? As many as contrary opinion say nay? The ayes have it.
Standing Order 176.
I propose that Standing Order 176 be part of the standing orders. Mover.
I thank you, Mr. Chair. I beg to move that Standing Order 176 be amended as proposed in the standing, as proposed in the order paper. Mr. Speaker, a very interesting one here is to empower the Speaker to discharge a member of Powers and Privileges Committee who commits gross disorderly conduct. This is basically the equity term that, you cannot, if you have, let me not even use equity, let's say this is a very influential and strong committee which is supposed to handle matters of conduct by members. If the member of that particular committee is not orderly himself, he cannot be trusted and used to judge the rest of the membership. So the Speaker, for example, for example, the honorable friend of mine, I'll not mention his name, who once used whistles in the House. You cannot allow that member at a particular point in time to preside over others in terms of disciplining them, because he himself would not be having clean hands. So he who comes to equity must come with clean hands. And Mr. Speaker, this also gives an opportunity to the smaller parties to also discharge their members from committees if they are disorderly themselves.
I propose a question, which is that Standing Order 176 be amended as per the order paper. Honorable Duale.
The Speaker, amendment to the standing order is very, very important business. And when you see the Speaker sitting, so Speaker, this amendment is very, very good. And I think it will go to even, you can't be in the committee that disciplines and is chaired by the Speaker. And then when your party sends you and tells you to become and misbehave grossly here, you forgot that you are supposed to discipline other members. And the Speaker, you remember, this House rejected that committee, ethics, to something called, which I think, standards committee. That if we had a standards committee, there was no way the Speaker could refer you to EACC or DCI. But in this House, I think in the 11th Parliament, they rejected. Mr. Speaker, these are going to also go to the Speaker's panel in future, that themselves, they are supposed to lead by example. They should not also make the House very disorderly. You know, sometimes it happens. They get so overwhelmed that they become part of the chaos. And I think they should learn from you that when you see the chaos are at unprecedented level, you have the opportunity to adjourn the House. There are people who have accused you of adjourning. And Mr. Speaker, finally, you know, this committee is good members first to know their powers and privilege they enjoy and the immunity. I remember in the 10th Parliament, Honorable Charles Kilonzo, I'm happy he's here, we tabled some very sensitive documents on the table. And everybody in government denied knowledge of those documents. And we were summoned by the Defense and Foreign Relations Committee, me and Honorable Charles Kilonzo. We was having tea. And that evening, we looked for our legal team at the legal department and asked them, what are the powers, the privileges, and the immunity we enjoy? And once we were given, we wrote about 5-page letter to Speaker Marende. And Speaker Marende says, and we told him, the powers we enjoy will only contribute to the documents we have tabled when that committee tables a report. Before then, we cannot become witnesses for this. So I think I'll ask members, it's good they know their power, and this should be in fact, this is the highest ranking committee, discipline. So Mr. Speaker, I think next time, the membership, we should even vet them. We should have even added, vetting, and ask whether they have got certificate of good conduct, whether they have got the previous cases of leading demonstrations. Because the moment you sit in that committee, Mr. Speaker, chaired by the Speaker, you are supposed to show the best of the best. Even the leader of majority sometimes can become rowdy because of government issues. But it is the members of that committee under your chairship. And I think this is a very good amendment I support.
Honorable Wino.
Speaker, I also want to support this. And also, if possible, those who are, after vetting, I agree with the vetting, those who have been selected, I think there's a need for capacity building. Because you cannot be in the panel of problem solving when you yourself, you are a problem. It's an act of oxymoronism, so to speak. So I think I agree and I support this wholeheartedly.
Honorable Kilonzo, you want to say something? Very well. Honorable Shamara.
Thank you, Speaker. In my considered opinion, this new Standing Order 177A.
No. Where are you?
Are we not on the selection of committee responsible for privileges and conduct of members?
No, not yet.
Okay, all right.
So, honourable members, I put a question, which is that Standing Order 176 be amended as per the order paper. Will as many as that opinion say aye? As many of the opinion say nay? The ayes have it. Put the global question, which is Standing Order 176 as amended, be part of the standing orders. Will as many as that opinion say aye? As many of the opinion say nay? The ayes have it.
Standing Order 177.
Propose that Standing Order 177 be part of the standing orders. Move on.
Chair, I beg to move that Standing Order 177 be amended as proposed in the order paper. This is to reduce the higher limit of membership of committees from 23 to 15. It's basically to make committees efficient. When in the last parliament, and Honorable Duale, who was majority leader, was serving in that particular position, there was a situation whereby there was need to create more positions of membership of committees in order to manage, because we had increased from the 210 members to 290, and therefore some of them were missing out on committees. So we increased at that particular time. What we have, and 47 women, so that becomes 350. What we intend to use, if we have cured this, is by increasing the number of committees, which will be in another another proposal. So therefore, it would be helpful to reduce the numbers to create efficiency. When members are too many, it becomes difficult even for them to even talk in committees or to give good contributions. So it is that is basically the justification.
Narok County generates huge revenue from the world-famous Masai Mara National Reserve and the agricultural sector. Two candidates, Moitalel Olekenta and Patrick Olentutu, are gearing up for the next governor of this county. What is their agenda for Narok? Don't miss the Narok County gubernatorial debate this Thursday, 2nd of June from Masai Mara University, exclusively on KBC Channel 1 from 9:50 p.m.